Just believe us, we trying to teach you the rights to read you. It's just procedure, baby.
Trials, instruction, procedure. AWS gon' teach ya. Trials, instruction, procedure. AWS gon' teach ya. Here's a tip, don't get it twisted.
Welcome to Attorneys with Swag. How's everyone doing? We got another good one for you. This is your host, Eugene Toussaint, and I'm here with
David Ourlicht,
Mehdi Essmidi,
and Nia Fung.
And we have a very special episode. This is how you know Attorneys with Swag is going mainstream. We got assistant district attorneys in the house that would not think would be possible. I'm very happy you guys are here. If you like what you guys see, like, subscribe, make sure you share, make sure you check us out and check out our merch shop. But now that we got the topic introduced, Mehdi, introduce yourself. Tell me where you're from.
My name is Mehdi Essmidi. I am born and raised here in New York City. I am a criminal defense attorney. I run my own practice. I practice federally and locally in states, courts, and I was a prosecutor in Bronx County for 5 years. I left in 2019. Before that, spent some time working in the Queens District Attorney's Office and in the Manhattan District Attorney's Office, as well as some time in the criminal courts in Kings County.
And Nia?
My name is Nia Fung. I was born and raised in Brooklyn, New York. I was a Queens District Attorney for 5 years. I left in 2022. I moved on to Department of Corrections. I did some disciplinary prosecution there for a couple months. And now I work for Joey Jackson Law as a criminal defense attorney, as well as an employment law attorney where we represent correction officers.
All right, and as they said, we're here to talk about being an assistant district attorney. For the layman, what's like the definition? What exactly does that mean? What does the job entail?
So prosecution, it can be both civil and criminal, but in the criminal realm, when a prosecution happens, you take charges, reports, either from victims or from state agencies, of criminal charges, allegations, whether it's through the penal law, administrative code, New York City rules and regulations, parks regulations, and then you have the burden of establishing the evidence and proving that evidence beyond a reasonable doubt to get a conviction. That's what a prosecutor's job is. Now, prosecutors have a unique authority. They have prosecutorial discretion. They decide what cases get prosecuted and what cases don't.
all law enforcement have discretion, though.
No, police do not have the same kind of discretion a prosecutor does. Prosecutor is the only agency, prosecutors, U.S. attorneys' offices are the only agencies that have statutory and constitutional discretion on bringing charges for a criminal case. Because police can't prosecute cases.
But they can arrest, and they have the discretion to produce an arrest or not, right? To pursue charges against somebody.
They can make an allegation.
They make,
well,
yeah,
that's the thing. Police make allegations.
Yeah.
They don't prosecute.
Well, like
they don't bring the case.
For example, like if somebody runs a red light, right, and the police pull them over, it's their discretion whether to issue a ticket or not, right? So if the police, even if the police see you commit a crime, right, they still have the discretion to arrest or not arrest.
Yeah, but you got to think about it like this. 95% of the time, police officers charge incorrectly.
Oh, 100%.
So
100%.
they don't have any, they have the discretion to
like
bring,
us,
yeah. They don't have the discretion to bring charges against you. They have the discretion to bring an allegation against you.
Right, but it starts with them. It's essentially, if they never officiate an arrest, then it never gets to you guys to determine what charges or what level.
We will never know.
Well, truthfully, police don't have all discretion, right? Like we know, especially for a domestic violence case, they don't have the same kind of discretion. Once a case is filed and there's a sufficient allegation which meets the standard for probable cause, which is really low in the state of New York and most states in the union, they don't have the ability to say we're not charging that. They have to make an arrest even if they think the case is not substantial or not supported.
But a prosecutor pretty much has jury nullification before it even gets to the jury. You're saying, like, you can be presented with the information from an NYPD, right, from the investigators, and they give you all the, and then you can charge with whatever, like the evidence aligns with, let's say,
like an assault to an assault.
Exactly. And you can say, you know, we're not going to, we have all this evidence, and we don't think that the facts surrounding this assault are worthy of prosecution, so we're not going to prosecute?
Yes.
Oh,
Yes
well,
and
I'd
no.
love to see that.
There's,
more.
I mean, you
Yeah, it does
wouldn't.
happen.
All right, I guess.
You
I mean,
wouldn't.
if you look at the arrest charges are always worse than what
Oh,
the,
no,
what
100%.
they
the
always-
prosecutor charges
They
are.
always upcharge and
Right,
you,
DPs.
as a defense attorney, you wouldn't see it because you don't have nobody to defend at that point. So, I mean, it happens often. Like police officers often bring cases that don't have sufficient evidence. It's a normal thing. It's not like all the time because sometimes you have to initially prosecute and then investigate later, especially if it's a serious crime. But if police officers don't bring enough out front, then it's not going to go forward to arraignment at all.
But even if they do, essentially, even if they do have enough evidence, like even if they have enough evidence, you can nullify the investigation, stop it.
You could have enough evidence, but your procedural has issues, and then that's the prosecution's discretion to not move forward because there's procedural issues. Everybody has constitutional rights, and so on and so forth.
I think what would be good is, because I was going to get into the difference between intake and the difference between being a line ADA and a part. So I feel like that's when the meat of this conversation we'll get more into how you pick cases, don't pick cases, and that part of the job. That make sense?
Just to be clear.
Yeah.
No?
If you get a case
That's not part of
sufficient
intake?
to put a crime and
Depends on the borough.
you don't file it, that's misconduct. And that's why we created prosecutor misconduct panels, and it's also an ethical issue. You still have a responsibility to prosecute crimes. Like you can't just go, I don't think this lady deserves to have her claim of rape, sufficient because she dated the guy for a year afterwards, right? Like you still have to investigate that case. Now, it is not uncommon to have a case come to you as a rape 1 and reduce it down to rape 3, right? It's not uncommon to have a DWI come to you as a felony because the person's had a prior, right? And you decide, you know what, we're going to reduce this one. Or even to have a case where maybe somebody had one too many at a birthday party, and they have their child in the back who's under the age of 16 and said, I don't think applying Leander's law is the right thing to do. That happens all the time. But the idea that prosecutors are generally getting cases from the NYPD and going, no, we're not doing it even though the facts align with a crime, that's pure misconduct.
Right, so it's not complete discretion. It's discretion to say, I think this is prosecutable, or that's not a word, but I think that we can prosecute this, or I don't think we can prosecute this. It's not discretion like the sense of, that's why I brought up jury nullification as a
I guess the application of the discretion is regulated.
it's
So,
based
I
on
mean-
procedural or evidence based. It's not based off of just like not wanting to or not feeling like
Well,
this
you
crime should be
can
prosecuted.
also talk about discretion in a sense of mitigation. There's multiple things that will mitigate a case while you're prosecuting it. And that can also be like a procedural mistake that an officer made. That's mitigation.
Right.
Or like what he was explaining, like the examples he gave, like if you look into the case or the person or the background of how they got here, those are mitigating factors which will give us discretion to resolve the case in a certain way and then go back to what he said, not take it to trial at that point. So it will start off as a felony, but we're resolving it as maybe a misdemeanor, even though the charges were a felony and made out a felony. Our discretion is to find the mitigating factors to bring it down to misdemeanor as a resolution.
And as defense attorneys, we also know we got to bring those mitigating factors to the prosecution. Right. They have no idea.
Or a discount.
Yeah, don't you love those?
Nice round discount.
What is
Everybody's
Everything's a discount.
Everything is
Everything
a
is a
discount. I
discount.
actually worked against you. Everything was a discount.
Everything's a discount. All right, so I feel like we jumped into the meat of it, but before we get there, because I know we're going to spend most of our day talking, what made you guys want to be ADAs? How did y'all become ADAs? I applied to be an ADA, so I have my own little story about that. Yeah, you didn't know, right? You thought you did.
Surprise.
You thought you was hanging out with a Kool-Aid drinker. No, I'm more of I have a mixed history, but I want that's going to be more for a segment in the middle of our conversation. So, what made you guys become ADAs? What was your path?
Do you want to start?
Sure. Well, I wanted to become an ADA only because, growing up in Brooklyn, New York, being around a lot of people that maybe had run-ins with the law or had to hire attorneys, And they, as well as their family, did not understand the process or the procedural part of it, right? That's one. And then two, there was always a negative connotation to the prosecution and what the prosecutor's job was. So, I mean, it would have been easy to become a defense attorney and defend all these people. But at the same time, it's like, why don't I do the opposite? Why don't I change the face of what prosecution is and change the perception of what prosecution is to people that I'm around? So they're like, oh, Nia, you could be a prosecutor. Like, oh, wow. Like, maybe they're not all so bad, right? So that's kind of why I decided to be a prosecutor. I have no regrets. I think the place of control, especially in a positive way of control, like knowing all the facts, understanding mitigation because you've been there or you've been around certain things, made me successful as a prosecutor. So I have no regrets. So that's why I became a prosecutor.
So I'm Moroccan, which is a country in North Africa. It's a third world country. My mother and father came here with very limited education and very limited resources, and they provided us a great life here. And part of the reason why that's possible is there was so much less corruption here in New York, in the United States, than there is in Morocco. Morocco, the name for prosecutor is muharriq, which means to drown someone. Okay? And the name for attorney,
Boat guy.
and the name for attorney is muhami, which is to defend someone.
Okay.
All attorneys are muhamis. They all defend you from the corruption of the system. Wow. And the entire system, they believe, is subservient to rishwa, which is bribery. If you have money, you can get whatever you want from anyone and take anyone's freedom. I loved that being in this country, being a first-generation American, having parents who had limited education, they were able to work, they were able to buy a home, they were able to live safely. We were able to live safely. And I really believed that the best way to serve and to be thankful for the resources and the opportunities in the country would be to put myself in a position where I could serve. And of course, I had this big ego, so I thought to myself, I'm going to take my big ego and put myself in a position where I handle the most important kind of cases and where I get to make a decision and I get to make sure that an innocent person is never convicted of a crime. So I thought that's why I'd be a prosecutor. And when I was a prosecutor, I tell you, I had many an argument about cases that I felt should not be handled a certain way. And I pushed, and I fought, and I believed in that, and I was always proud of that.
I just find it, because I also grew up here. I grew up in Manhattan, it's to both, right? So I grew up with aggressive police interaction since I was a little kid, right? Mm-hmm. And that's what I saw my peers and people, and that kind of led me to, end up suing the cops. I was a named plaintiff in the city Floyd versus City of New York to challenge the unconstitutional practice of Terry stops here by the NYPD, and then that experience made me want to continue to fight against kind of what you were talking about, right? I actually think that this country is actually a lot more analogous to what you were saying happens in Morocco than we give credit to. All of my clients when I was a public defender were people who did not have means, right? 90% of the people that walk through any criminal court in any of these jurisdictions are people without means. Mm-hmm. They're also people of color, right? And so the seeing the difference of clients I represent now that have means and the dispositions I get and who are majority white and have means versus what I did as a public defender, kind of it's interesting. I think that the further we continue down this path, what I don't think it's able to stop down this path. I think we are barreling towards this. Is actually what you said is happening in Morocco. I think that was at least my experience growing up in New York City. I'm black and white. Half of me of my family are not, have been here since slavery, and the other half were immigrants. But it's just interesting seeing that we all share really a same we all have a lot of the same experiences and come from the same place, and it led us to different places, and it's interesting to see because I respect what.
It's a fair question to ask us all, right? Because you're a defense attorney now, private attorney.
Yeah.
Now we have two ADAs who are both private attorneys. What I feel like you're saying is that if your client starts off with money, which is the difference for you because you see a public defender and now your clients who are paying you, you feel like purely because they have money, your offers are better?
And it could be a jurisdictional thing because like where I practiced as a public defender, I was in Manhattan the whole time. That's where I was from. That's where I wanted to practice. I wanted to serve the community that I grew up in. I thought it was an honor to be able to I represented 7 or 8 of my friends in the course of my career at Legal Aid, right? And that was what motivated me and kept me, doing the job, which is a hard, thankless job.
I do it for the discounts.
But no,
call it the discount show.
That's good. But
no, I do it because it's like it's good
absolutely.
getting discounts.
It's talking about I can't talk about cases that I'm actively that are open and stuff like that. But yes. Do
you guys agree?
Do you think so? I mean,
well, you wouldn't know because you don't represent public defender clients. But I guess you think of your clients' starting point plays a role in the ability to.
I mean, I think that unfortunately we live in a place that's very diverse. People are diverse with experiences, knowledge, what they do, how they think, their walk of life. So you're going to have a diverse office, whether you're working in the legal aid or you're working in the prosecutor's office. Everyone's going to have different opinions on results, right? So that without taking away your experience, I have a question. Do you think that maybe your clients are getting better results because they have a competent attorney? Most private defense attorneys have a background experience in some type of criminal realm, so they know what the prosecutor wants to hear. They know what they're looking for. Also, I don't know if it's necessarily the clients or if it's just you as a private attorney. I feel like sometimes private attorneys just get more respect in general in conversational pieces because it's not someone you're dealing with every day. Like if I'm dealing with Eugene every day, I know Eugene. And when I used to deal with him and he's calling me, I'm like, Eugene calling me, he gonna have to wait. But if you,
my discount, bro. He about to tell me
some story about everybody's innocent, and granted, maybe they were, but everyone was innocent. So I knew what Eugene was coming for. But say you called me, I'm gonna be like, okay, let me see what he's saying. You have the time to be on the phone also to sit down, talk, write these big packets and stuff like that. And I know the time you put into it. So I can't answer your question or your experience, but maybe it could be you and not necessarily the client that has the perception on the prosecutor that's changing the offers.
After the mics go off, I have 2 examples that are the 7 years of practice are insane and once again, it may be because Manhattan does things a very particular way.
Is Manhattan the worst or which one's the worst? Staten Island's the worst?
Manhattan's the worst. No, Manhattan's the worst.
No, Staten Island is definitely the worst.
Yeah, I haven't had bad experience in Manhattan as yet.
So here's a funny thing.
I mean, but it depends on the case.
I was a prosecutor in the Bronx.
Yeah.
So my victims, people I was representing, were the most poor, most put upon, least resources. Like they were, half the people I dealt with were immigrants. Half of them were desperate. I was a domestic violence prosecutor for over a year and a half, and I saw so many people whose choices were be hungry and go to a shelter with your 4 kids, or keep getting beat. Right? When I started doing violent crimes and I went to the trial division, it was the people I was representing where people were getting stabbed by like there was a guy in the deli, got his face slashed. I spent 6 months just trying to get him to work on the case, just to be cooperative so I could defend him against what happened to him. He got his face slashed with a kitchen knife. He wouldn't do it. So,
good for him.
But the funny thing was, as a student ADA in Manhattan, I truly felt like we were not on the side of the angels. I did not even apply to be a prosecutor there. I had no desire, and I
interned there
would have had an advantage to get a job. A lot of people that I did my internship with all got jobs and applied and got in there. I applied to the Bronx. I had my offer before anybody else got an offer, and I was happy to take it because I wanted to serve people who I felt were hardworking, regular people like me, not getting a fair shake.
So what is the difference? What does that mean? Like, what's the difference between because I know you're saying there's a difference, but what is the difference? Why?
The community is different, right? Like, your juries are different. So your juries are different, so your representation is different. The juries in the Bronx, they see the humanity in circumstances. The juries in Manhattan, I'm not sure they do, right? Like, I'm not sure that they are, I wouldn't call them fair. I really wouldn't. I mean, look, the jury you get, you pick, right? And you work really hard to pick a good jury. And, one of the best trial attorneys I ever knew used to say, like, when you are picking a jury, you're trying to find a jury that's going to listen to you. It's going to give you a fair shake, right? But when you're in Manhattan, they take it's just like if you have a civil case in the Bronx, they're going to give you a big reward, right? But if you have a civil case in Manhattan, they don't give those big rewards the way they would in the Bronx or Queens or even Brooklyn, because they are more concerned with the finances, and the environment is much more political. It's like being in Westchester County. We were talking about Westchester County a little before the show started. I would literally go to court, and there'd be lawyers there who are like, "Oh, I gotta make my tea time in an hour. The judge has a tea time right after me." Like, that's a funny conversation to hear, but realistically, they all are. It's a small enough group of people, and everybody can just I remember I had this case with two wealthy. I had a wealthy client. The complainant was a wealthy guy, and they were just making both the prosecution and myself miserable because they could afford to drag the case out indefinitely and keep delaying it and keep doing things that make it more difficult and keep filing new cross complaints in the civil courts, and it was making the criminal case impossible to resolve. So I see it all the time.
What does that mean? I don't know what that means. A cross complaint in civil court? How does that work with a criminal court case?
Well, think about it.
You hurt me, I hurt you, we both sue each other.
So you file a cross claim against me, then I file a cross claim against you for something else that you did, and you just keep enjoining issues until you have a web.
But you can do that. You can make a criminal case complicated using that strategy?
Yeah, because if the civil case is creating new discovery and new stuff that is considered in your criminal case, you're going to have an issue. You don't want to go forward with a criminal case when there's a civil case dragging out.
I didn't know that was a thing. That's a thing.
Is this a Westchester thing?
It can be anywhere.
It can be, but is it a Westchester thing?
This is unique to this particular case.
I said it can be, but is it a Westchester thing?
Are you saying
this is unique to this case.
Because in our boroughs, officers don't take complaints after the fact because it's considered retaliatory. So they're not going to make an arrest unless you made the complaint.
No, you say civil.
First or simultaneously.
These are civil cross claims that keep coming up, right?
And then it's causing a criminal issue?
Because you can't resolve your criminal case because they keep getting new discovery you need for your criminal case.
And then I would be like, Your Honor, this is a civil matter. Can we just get an ACD and we handle it in civil court if it's so serious?
The judge doesn't decide. The prosecution decides, and we're the ones looking for the discovery.
Why do they care?
Shit. All right. Dang, I didn't know that. All right, so...
it's interesting.
It gets messy.
It's a problem.
It's messy.
It's interesting because just your I don't know if nomenclature is the right word. You guys viewed that you guys were representing the people, right? Mm-hmm. And I always viewed the prosecution to represent the state. And I always, I had as a defense attorney, I had clients, right? As a prosecutor, it doesn't matter. For example, a sign of a sworn deposition, right? I would, as soon as that's signed, the prosecutor, in theory, doesn't have to listen to the victim anymore because they have enough to continue to put. And it doesn't, and not necessarily doesn't matter what the victim, the complaining witness. I don't want to call him a victim. I'm a very biased person.
I mean, you're a defense attorney.
I
That's
can't
fine.
help it.
Respectfully.
The complaining witness is kind of a lesser. It's not about them. It's about upholding laws and the behalf of the state, right? And
Yes.
that's always how I view. Which, for me, which somebody who a lot of my childhood trauma comes from the state, I've always viewed that as I don't want to
Say it. Safe space.
okay, like look at what the state has done throughout history in the name of whatever it wants to be in the name for, whether it's in Europe or in like a certain time period there, or like here, right, in America. It is always about, you know, it's always about business as usual, and the humanity is trampled within that because it's not about the individuals. It's literally about upholding laws so other people respect laws, so da-da-da-da.
Right. I mean, formally, we represent the state as a prosecutor. You represent the state. That it is what it is.
Right.
There's multiple times where I had to explain to victims, complaining witness, whatever you call them in the moment, that I am not your attorney. I represent the state. However, if you have any questions about the process, I'll keep you updated, and et cetera. Because a lot of times they do get confused with what our role is, and you have to let them know that I don't represent you. I represent the state because I'm upholding the laws because someone committed a crime.
And
I can tell she was in Queens.
Why? Why?
That's 100% a Queens demeanor.
90%.
That's not the way I was trained.
90% of the
How were you trained and let the people know your borough?
So I was lucky enough to be hired by Rob Johnson. And God
What
bless the
borough is
man, that's Bronx County.
Oh, you were in the Bronx.
And Rob Johnson, one of the longest running district attorneys in the history of the state of New York, was the best district attorney I could imagine. Okay. He, during our orientation training, he came down and watched the documentary about the Central Park Five with us. And then he gave us a lecture at the end, and he goes, listen to me. If I ever find out that one of my prosecutors that I hired and swore in did not investigate and make sure that there is no corruption in the case they are prosecuting, that would be the worst thing for me. I want you to investigate. I don't want to ever hear about a mistake, an error of a harm like this being done in my county. And then moments later after that, he swore us in. And I took that to heart. He used to come to my office and check in on my cases. And he'd look at case files. This is the district attorney, hands-on. And I remember they used to tell us, if you haven't spoken to your complainant on a complaining case within 72 hours, and they call us, I will take that call and I will come and see you, whether it was him or his executive or our division chief. And we took that seriously. I never failed to. The second the file came, I called every witness. I notified every officer. And it didn't matter if I had 15, 20, 30 new cases. That was my job, and I stayed late to talk to people. I met with clients after 5 o'clock. I never, ever blew off a victim.
Well,
And
that's
that was
the job of an ADA. I mean, Queens was exactly the same. We had the same requirements. And when I say the state, remember, I'm in a county, so I represent the people of Queens County, essentially. And that is essentially the state, because you're not representing a specific individual. But you were required to call your victims. You couldn't, back then, you couldn't announce ready for trial unless your victim signed a supporting deposition. So how else was I getting it? By calling them, speaking to them, talking to them. But you had to explain to them the distinction of, I'm not your attorney, because I'm legally not your attorney.
It's true.
And that's, I think, the point I was trying to make. I was always in communication with my complaining witnesses because I had to be. I had no choice. But
your duty isn't to them.
my duty isn't to them, and they needed to be clear about them.
Right.
My duty is to the people of Queens County, and that is Queens County as a whole, and that's who I represent. Because a lot of them would view you as their attorney, and it's like, I'm not your attorney. And you know why I say that? Because for example, on a DV case, they call the cops, person gets arrested, we have a defendant comes to the house. Who are they calling? Me. Call 911. I can't help you. I can't leave my house to come and arrest anybody. I can't defend you. Call 911 and let them go through the process. The case will come to me, and I will call you when he gets arrested. I cannot do anything before that. And that's where the clarification needed to be made, because complainant witnesses essentially are needy, and they should be needy, but at the same time, they have to understand how the law works as well.
Yeah, I won't lie. It wasn't until I became a public defender and interacted with prosecutors that I realized that they weren't the boogeymen that I grew up thinking they were. In the sense that like they can't make a case happen. Most prosecutors I know don't control the investigations. I don't know where these warrant arrests come from, but I've never seen them. And they must be going to motherfuckers with hiring attorney money, because you probably get it started with a warrant, but I as a public defender, I get almost 0 cases that started with an arrest warrant, that started with some of them are search warrants, but not even search warrants, not even like you were the guy I wanted. Search warrants is more like, I know drugs are here, I know guns are here, so I'm gonna go and start fishing. And
that's so crazy. I've had so many target cases.
It's
and
iCards,
you've been in longer than me.
Oh, well, you as a prosecutor probably have them, but I guess who are the attorneys that end up getting?
Well, it depends on the borough, because every borough has different process. But a lot of boroughs have the writing situation. So, like, if an officer has an inclination, they'll go to that person and develop a case.
Okay, so then, all right, so then let's talk, how does that work? I feel like that's a good topic to flesh out.
I think it's the iCards are the reason why you don't see a lot of them.
Investigation bureaus too.
Well, yeah.
Because iCards are,
I don't see them, because why? If you arrest someone for just probable cause, iCard, right? Why get an arrest warrant? I get that.
I don't think an iCard is probable cause. I think an iCard is just it's like effective a level 3. You have enough.
No, it's probable cause to arrest.
iCard, really?
It's probable cause to arrest. Turn yourself in.
It's the same thing as I'm an officer. I saw a crime. I'm chasing. I call it over the radio. This is the car. Stop that car.
It's turn yourself in, or I'm coming for you.
Yeah. But acting on.
So then why isn't it? Why don't, if they have probable cause, then why don't they just get it signed by a judge and actually have a warrant instead of
an arrest warrant?
Because it would be impossible.
Who has the time for that?
Oh,
it's too many.
That's why there's a lot of iCards floating around for months.
It's a functional thing.
It's an NYPD thing.
Because
there's too many
cases. Okay.
Yeah.
Eventually, they sift through their pile of stuff that they put to the side because they got to close their cases out. Because iCards, on an NYPD perspective, iCards, the case stays open. The detective's case stays open. And then it's going to be one random day that the detective is like, oh shit, I got like all these files, because their sergeant came and was like, you got so many cases open, you got to close them out. And it's iCard cases. And then they start sending warrants out. But warrants usually, practically speaking, could only go out for very serious matters. And in my opinion, DV is a serious matter, but sometimes that's like at the end of the totem pole of things they go out for. They're just waiting for you to... How many times have you been in an arraignment and your client is a DV case and you're like doing a bail argument or a order protection argument? Your Honor, this happened 6 months ago, and then the judge is like, and where has this person been in 6 months? With her?
Yeah. That's the best.
Living his life.
Something happened, but they've been living fantastically since then.
What are we doing here, Judge?
Can you give me the limited?
She'd like to tell you she lied. Yeah. I have the affidavit that's notarized.
You know what's so funny is that
Because they wait on these iCards.
There's been two, like, I remember when I started being a public defender in 2014. And there's been 2 huge changes since 2020 of all of our practices, since we're all defense attorney now. 100%. Discovery, that's huge.
Huge.
Yeah. But then...
bail reform.
Bail reform and discovery.
Well, bail reform, discovery, but then the order protection changed with People v... Fuck, I'm blanking on it. But what makes it... Crawford. People v. Crawford has changed our fucking existence.
I would order them at every single... I would ask for a Crawford hearing at every single arraignment.
Well,
Do you really?
Yeah.
Well, so I can't
ask if they live together, of course. But
well, whatever. I mean, if there's a property interest, it doesn't have to be living. It could be like he has stuff there.
So just for purposes of the viewers, every borough views DV differently.
Yes,
So Queen's perspective, intimate relationship is not enough for domestic violence. You have to live together, have a child together, formally live together, or have been married.
Yeah, Manhattan.
Or married or divorced.
If you have any intimate, you're an
You're
intimate
DV,
relationship.
right.
Yeah.
Yes.
Yeah.
I mean,
And I
almost all of the
think
counties are
Always
Brooklyn,
like that?
I think
Oh.
Brooklyn is the same. I can't speak for the Bronx, but Brooklyn is
the
the
Bronx,
same.
Staten Island, they're all like
Any intimate relationship is DV. Queens, intimacy is not enough. So that's where Crawford hearings don't happen as much in Queens, I feel like, because
Yeah, and so
it's just boyfriend and girlfriend. You just take them to DV. I mean,
Yeah.
like, take them to a regular party at that point.
Some of the judges won't even do the Crawford hearing properly. They'll require you to do it right there in front of them with
you
no
have to have
time to prepare
you
a
have to have
lease or
time to
anything.
prepare.
Yeah.
The statute is clear.
What
You
is
just
it?
read the statute to the judge, and then if they want you, just.
Crawford,
Crawford
Crawford is 48 hours, right?
You
in-
can ask for up to 48
in
hours.
Queens. What I can't speak for any borough because I've only practiced in Queens. In Queens, once Crawford came out and people got used to it, basically what it became is that instead of doing a Crawford hearing, like if I have to do a Crawford hearing, then I fucked up with the arraignment. Because if I can line up, there's two things I gotta line up. Like, really ain't no history, right? She doesn't want to pursue the charges. She wants him to come home. If I can get those three things, most judges in Queens will allow him to go back home. Unless the next thing they're gonna ask the ADA is like, and this obviously depends on the judge. Because some judges, you give me like, she feared for her life, or regardless of all that, they want to afford a protection. And then you get your Crawford hearing 48 hours later. But if you can establish that this is kind of a bullshit case, Queens judges will.
Even with the DIR factors.
Well, so what I do a lot.
Those DIR factors are always filled out wrong.
Exactly.
Yes, I know, but when
They're never reliable.
when
The
I
fact
was-
that we even pretend they're reliable is
When
not-
I was at
I-
ADA, when Crawford came out and I was ADA
Yeah.
and I was supervising arraignments, those DIR factors were the things that was the turning point.
Yeah,
for the
in
judge.
fact. You know what I would.
Because if you write
Strangle.
has
access to guns.
and then the worst one yet, which is the Vegas one, has the violence increased in the
over-
past
yeah.
6 months.
Yeah.
What are we talking about?
You know-
Today is the 6th month. It is increased. And then you have the officer standing over them like, yeah, I'm reading that shit into the record. I'm sorry, I'm reading
But
it
here's
into
the thing:
record.
the officers
It's the
are checking those
evidence-
boxes off, not the complainant.
evidence.
Yeah.
100%. It's
So what-
all done by
so
the
what I
Every
always-
single complainant will tell you
when
they
I-
are not the ones checking those boxes
When
off.
I really want my client to, like, well, obviously I always want my client to go home, but when I'm smart enough to think of it, what I would do is ask those questions to the CW at the time I'm talking to them. And I'll go, okay, so now I'm going to ask you these questions. Are they yes? Are they no? And did you mark yes on this paper? So that when I get in front of the judge, I can sit there and go, I don't know what that paper says. I wasn't there. But what I can tell you is I asked my client, and they said no, they said yes. Because you're right. You're 100% right. Depending on those answers and depending on the judge, they might not give a fuck about Crawford. And just for clarification, I'm going to try my best to reiterate Crawford, because I just know it gets me this argument.
So Crawford is.
Oh, thank you.
So when People v. Crawford came out, prior to People v. Crawford, order protection
We're giving out like Skittles.
kicks someone out the house. It kicks
Yeah.
someone out the house, whether you've been living there, whether your name is on the lease. Order protection means in a DB case, you're out the house until we
Family court
figure out, or family court figures out something.
Or you
Family
have like a real separate space, such as that they live on the first
Two
floor, I live in the
separate
basement.
entrances. Two
With
separate-
separate
even-
entrances,
even
they can
that.
do what's called incidental contact.
two separate entrances, so you'll have a full order, but it's incidental contact. What Crawford did is basically said, if the defense attorney can prove that this person has a property interest in the property, they can kind of go back home, essentially,
Yeah.
right? However, I will say that even with the Crawford, and I can really only speak for Queens in this type of stuff, this type of realm. I feel like a lot of the Queens judges are very reasonable when it comes to certain things, because they let you as defense attorneys go and make an attempt to call the complainant witness,
no.
and then make your own representation in that moment.
I did that in Manhattan all the time.
And
if
then-
I could get
Okay.
and I would just have somebody else on the phone so that way I wouldn't witness myself, and then I'd just be like, well, how do you feel? What do you want to see happen? You know, and then if it's like, oh, I don't really, this is enough, I'll be like, okay, well, look, I can't give you any legal advice, but, don't sign anything, don't answer the phone call when the DA picks up, and if you do those things, then
Well, that's beyond Crawford.
Don't answer the phone when the DA picks up.
That's an instruction. Don't tell
I
people that.
know, like,
I said I'm not. I specifically said.
Connor,
I cannot give you legal
We
advice.
definitely can't leave that in the final cut
Don't
because
answer
somebody's gonna put him up on ethical charges.
I know.
We're cutting that one out, Connor.
He's
All
gonna
right.
bring it up.
After Crawford,
I think it's like
when
toting the line.
When I'm arguing Crawford, right? What I sit there and ask my client is like, hey, they're gonna issue a order of protection, but if you are okay with them coming home, not the client, the CW, the victim. Like, I'm not your attorney. I can't give you any advice, but I can explain what's going on. They're going to automatic issue a order of protection, and I can argue there's a reason that shouldn't be a physical protection. There's a lot of factors I could argue, but the most important factor is how do you feel? Do you want him to come home? Are you concerned about him coming home? Or do you feel it's unsafe coming home?
Is that part of a Crawford standard? What are the standards for Crawford? I know it's property interest.
Property interest, and then
that's the thing.
And then it's safety to the complainant.
safety issue,
and
yeah.
you have to weigh.
He's trying to figure out the property interest is almost always there because they live together. Right?
Yeah.
Like,
Yeah.
But the issue
Sometimes
is
it's
whether or
not,
not you can
though. 'Cause
overcome
sometimes they're there for
the
like a
safety.
month.
Effectively, it's just making an argument.
That's
for a
squatters'
limited-
rights.
It's making an argument for a limited.
A month you can stay in a house without paying
But the
rent for 7 months.
the judge
in the
also-
family housing court.
The judge,
I mean,
the judge also asks is, do they have someplace else to go?
Yeah. I mean, look, I'm not. What's the word? Like betting against myself, right? So like, this guy could be fucking have several places to go. Like, I'm not gonna. I don't give a fuck about that part. Like,
I don't think it takes away from the property interest, regardless of whether.
no, but I'm just saying that is a factor. Like, for example,
the safe way
like
and the
if the
safety.
victim ends up saying that to the prosecutor, and so the prosecutor can reiterate that it will be a factor the judge considers. My point is simply, as a defense attorney, I don't give a fuck if you have somewhere else to go. I'm not going to mention that on the record. I'm making a fucking Crawford argument. Like, whether you do or do not have somewhere else to go is that ain't my fucking
Because I know as
problem.
a
I don't-
prosecutor,
that's
we
not
used,
the
we used to
standard,
make
though.
that argument as a prosecutor. Like,
So-
the victim told us that he has
But
his
that's not the
mother's house that he
standard.
can go
Let's
to.
be clear.
That's not the standard.
The standard.
Almost everybody has somewhere else to go.
Not true.
They can go to a shelter. Almost
Oh my
everyone,
God.
right? That's not the standard.
Well, that's a little different.
The standard is, do they have a substantial interest in the property?
Substantial is, yes.
And
that's
generally,
important.
if I live in a house, I pay my rent. I have all my housing here. All
Mail
my mail
goes
comes
there.
here. All of
Yeah.
my everything is
you
billed
pay
here.
a bill
I have an
there.
interest.
Yeah.
And half the time, these people pay at least half or more of the rent. So what you're saying when you're looking at this person going, you don't have a substantial, go live on your buddy Bob's couch and still pay rent, because by the way, she can't pay the rent or he can't pay the rent without this other person there. That's completely ridiculous.
Yes, and I think we're talking in a realm of complainant witnesses that want, and I don't want to be sexist, it could be a male or female as a complainant witness, but I'm just going to, for purposes of this, that want him back home.
No,
when you have those
not all the
complainant
time.
witnesses that screaming and yelling that he ain't paying shit, it's not his place, and blah, 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 you don't really, how do you make that argument at that point? Tell me.
They do it all the time, and judges order that order of protection anyway.
That's what I'm saying.
Yeah.
Once the complainant witness is screaming, yelling, and
So,
jumping, and the prosecutor going off,
on a Crawford
you're done.
argument, depending on the
There's no
allegations, right? On a Crawford argument, depending on the allegations, if you cannot get the complainant to co-sign that they want them there, right?
You're done.
Then you're not 80%. You're done. Now, if it's bullshit allegations, 57-year-old defendant, right? Never been charged before. Bullshit allegations, like kind of like a assault 3, but it's not really assault 3. You'll get a judge even without them co-signing, just doing it on faith. Like, it qualified counts, and like I feel like she's safe enough. I guess I don't know how to do the math, but you can get Crawford instilled without the CW cosign.
Yeah.
But the easiest way to do it is get the CW cosign.
I mean, if you get the CW cosign, then it should be your argument at the judge should be for limited order protection based off of that.
Yeah.
I mean, for
It
my experience,
But some judges
I've
don't
done a
do
lot of Crawfords in Manhattan because every single DV case they issue almost all the time a full order of protection, and it always excludes somebody from the house. And all I have to do is say, Judge, I want a Crawford hearing. My client has a substantial property interest. That's it. then they have to order the Crawford hearing.
Yes,
and then,
it's mandatory.
Yes, 100%.
I'm trying not to do that.
They can't
You got private time.
Crawford hearing. And so once you get the Crawford hearing,
I'm trying to do that arraignment.
then once you
I am
get the
not trying to
Crawford
do a Crawford hearing.
that's when you show the substantial property interest overweighs the potential risk to the.
Because you had time to prep.
An argument like it's not a hearing. You didn't present anything.
Yeah.
Well, you
can
present some information at
Well,
a real
Crawford hearing.
Well, you can present at an arraignment. You're not going to call.
No, you can't. You can't. You just request it, right? Like at arraignments, and then you have.
He
the
does this
hearing.
in Queens, where they
He does it
at
at
the arraignment.
Oh, no,
are
how?
insisting on.
You don't have enough
They don't
information.
even have a real Crawford hearing. They
You
just go,
can
go
request
ahead
a
and make your
date.
arguments, and you go.
Well, no. So
You
what-
can request a
No,
date.
let's be clear. In Queens,
That's just a procedural
you make
allowance.
your argument as if it's a hearing without the ability to really do it with calling witnesses.
Yeah.
To the best of your ability, because most judges, if you do a good enough argument, they will just give you the limited.
Right, so you're making a limited order of protection argument. You're not making like.
Yes, but you
They're
are.
using Crawford
I
facts.
guess
using Crawford
What
for
happens
that.
is you
They
can
would
even,
still give you a Crawford date, though.
Exactly. They'll still
If
give you a
they
Crawford date,
deny
yeah.
you, they're gonna put it on for
Exactly,
Because
yeah.
Crawford is more complicated than what a limited order of protection is, right? A limited order of protection has to do about the safety of the complaining witness and like the least restrictive means, more or
Yeah,
less,
Crawford
right?
is
And
don't
a
kick me out
Crawford
of
is
my
like,
home.
Yeah.
Exactly. I have a property interest and this person isn't at risk. But even if there was, substantial claims of violence, the property interest has to be weighed against whatever harm could potentially be.
Yeah.
But do you guys handle these cases in family court at all?
I just started doing family court today.
So
I'm a family court lawyer today.
Congratulations.
Thank you. I don't like it.
So when you're in family court and you file a petition for an order of protection or you're defending against one,
Right.
the exclusion from the home is not a guarantee. You have to show
Oh,
aggravating
interesting.
factors.
'Cause it's not a criminal
for example,
order of
on an
protection.
aggravated harassment case or a criminal mischief, like, I tried to grab your phone,
Yeah.
like, they're not issuing exclusion from the home for that.
Interesting.
Like, and the fact that you think that, and the thing about it in criminal court is they have aggravated harassments. They have, phone call cases.
What's
like,
an aggravated harassment?
Aggravated
extra loud and shit.
aggravated harassment
One
is
of
you
the
send a threat through a text message or you call somebody without, and the complaint says they had no reason to call me, even if you live together.
So calling someone and making a threat or texting someone and making a threat is an arrestable offense. I hate that charge.
I mean, it literally, it was found unconstitutional,
literally
and they brought it back, and it's
hearsay
basically the
charge.
same exact statute that they made
scary
unconstitutional.
charge.
Nothing has changed.
It's a hearsay charge.
And they made it
It's
even
like-
worse because they added
Yeah.
a misdemeanor where they basically took regular harassment and made it an a misdemeanor now on the subsection 4.
And you can get arrested for aggravated harassment while you're in an argument. So you could be like just cursing somebody out in an argument. I'm gonna beat you up, and there's your arrest right there. That's like hate that charge.
And also,
Basically,
prosecutors
they made
file
the
it,
90s
even if it's
arrestable offense, 'cause that's all the 90s were.
it's like an incidental. It's
fuck
like
you
if
up.
you don't do
What
this,
did you
I'm
say?
gonna do this.
Yeah,
What did
Those
you
are
say?
not immediate enough under the law, but they still charge it.
yeah. Based on the relationship.
All right. Well,
Go ahead.
just let's try to get a little bit back on topic.
Yeah.
So you guys want to be ADAs, you become ADAs. What is that beginning experience? I know a sense of it in Queens where it's like you spend your first 2 years, you're either doing intake or you're doing line ADA, right? That's a fair definition.
Yeah.
Is that the experience in all boroughs, or is there something more complex?
Yeah, so I mean, when I started in Queens, you had to do intake and criminal court as a rotation. So you held a caseload of like over 200 cases, and you also had to write every cases. So 2 weeks, 4 weeks, 2 weeks, 4 weeks.
Simultaneously?
Yes.
Oh wow! I thought it was like one or the other.
No, so they changed it essentially, and now you start off either in intake or criminal court.
Okay. That's how it is now.
Or DV, and then I think some people do appeals. And most boroughs is like this. They have like you start off in one of the ones, and then you do a rotation. And by the time you try to rotate into like maybe 2 out of 4 or 3 out of 4, you should have enough experience to advance to do felonies. How the experience is determined is very.
Is there a timetable like?
And what are different, like what is the difference between each one? Like flesh it out.
So the timetable part of it is hard because I feel like, especially from my experience, I started as an ADA in 2018, so I've only been practicing for about 6 years now, and almost 6 years, I should say. And I feel like the timetable changes with the time. So like if they used to advance people every 2 years, maybe the times make them advance people every 1 year. When I started, you used to advance based on experience, like how many hearings and trials you got. You had to apply to advance and so on and so forth. So I think that.
So if you didn't apply, it wasn't even considered?
No, but
Ooh,
now I know, and also other boroughs, that you advance based on age. So like, this is your class, it's time for you to move up.
Manhattan,
that
you
sounds
get
worse.
1 year, because I'm always friendly with DAs. Like,
So Manhattan, their boroughs are their bureaus are mixed.
Yeah.
So there's this bureau and there's felony and misdemeanor assistance.
Yes,
Brooklyn is the same. It's this bureau and their felony and misdemeanor assistance. In Queens, this is criminal court, all misdemeanor, and then this is felony. So your advancement, whether you're in the same bureau or whether you're like separate, like how Queens is based on like either experience or time.
Yeah, because in Manhattan you get 1 year in criminal court, and then after that 1 year completion, you drop all your criminal cases and you're in Supreme Court and you're handling felonies.
Brooklyn has
that's fast.
Brooklyn has a grand jury bureau. So you go to a grand jury bureau and all you're sometimes holding a caseload, but all you're doing is grand jury.
It is grand juries,
right?
Interesting.
And so all your Brooklyn ADAs, that was just a brief description.
The comments gonna be like, fuck out of here, that's bullshit.
Don't come at me for it, but yes, so that's a process as well.
How's the Bronx, and then define what the fuck y'all saying? Because I use a lot of words. But again, I know, but I know my audience don't.
So it's not for me.
So under Darcel Clark, when she took over, she went to an entirely vertical system. So most of these DA's offices run horizontal systems. Mm-hmm. What that means is you have different divisions handling different things at different levels. So you have a grand jury bureau that takes a case, investigates, indicts it, and then sends it to a felony assistant. Right, in Brooklyn, the same thing happens in Queens, right? And the same thing happens.
Queens vertical?
No, Queens. Yeah, you get your case, you indict it. You get it out of
but
the
what
way.
you get changes.
Because even in Manhattan, some felony assistants write up cases.
Well,
and
some of them write up cases
ECAB.
in Manhattan.
And
Manhattan does a unique sort of. It's sort of like vertical, but they also will write up cases that are domestic and that'll get handed
over.
Yeah.
Right.
So there's specialty cases that they won't keep.
Yeah.
And then of course there's a special narcotics cases, which special narcotics prosecutor takes from any county.
Right.
Yeah.
And I believe
Staten
Island has the same thing. They're horizontal. They have, you write your case, it gets assigned to somebody, and then it moves around, and sometimes it moves around several times, right? Mm. So when Darcel came in, she took over and made an entirely vertical system. If you were domestic violence, you wrote domestic violence cases, felony or misdemeanor, and you kept them. If you were a felony assistant, you wrote up felony cases and you kept them. And the same thing for misdemeanors, and the same thing for PSNYs and complainant cases. PSNYs are cases that are law enforcement or state agencies as the deponent in the case.
So, speaking when you first started and with the new DA, if you know, what is the experience for like a brand new hire? Like, what are they doing? Like, is it like Queens where they're doing intake, then they're doing line, and then do a little bit of appeals, or are they only doing intake, or they're only doing line ADA? So
when I first started under Rob, he had this approach where basically it was horizontal still. So you would get assigned. Almost everybody went to criminal court, and if you were in criminal court, you had different supervisors, and you had one bureau chief, and you would get sent. You would rotate into the complaint room where you would draft up cases, and then those cases would get passed around based upon the supervisors, and then you would keep a caseload and you would handle your cases. So maybe you were in the complaint room 2 days, and then the other 2 days you were handling cases, misdemeanors, and then.
But would you only get the complaints you did, or you might get other people's complaints?
You might get someone else's complaint.
Oh, okay.
So in Queens, when I was doing the both, you kept your complaints. Except for the felonies, because you were a misdemeanor assistant.
Exactly, but then you were in a mixed bag where some days you were doing intake, some days you were doing line, which makes sense because now you're making your cases. It's almost like you're a chicken and egg.
I know my complainant from the rest, right? It's not like that anymore. So the intake and ECAB, we use it interchangeably by borough. They essentially, for the viewers, they write up the cases when the police officers bring it. Mm-hmm. So what we're talking about right now is once that case is written up, where does the case go? Does it stay with the person that's writing it, or does it move to someone else?
Exactly.
And now in Queens, it moves to someone else because there's an intake bureau.
Exactly.
No one in intake, everyone in intake is in intake.
Yeah.
That's their bureau, and they are not working on. They don't have a caseload.
They don't inherit anything that they create.
No, exactly.
Okay.
And I feel like what Brooklyn. I don't know.
Brooklyn, people who write up the cases don't necessarily keep them. I know for a fact that's the case because somebody write up your case and you go to your arraignment, they have no idea who's going to have that case, and it gets sent to a zone, and it gets assigned to whoever's going to get it. And you might have somebody working in their.
Brooklyn's bureaus are based on precincts.
Yeah, so they have red zone, blue zone, green zone. So like, and sometimes you have red zone is two different sections, of the county. But what ends up happening is whoever's in the complaint room, their early case assessment bureau, is what a lot of people call ECAB. They write up the case, and then you don't know who's going to get it, right? Yeah. So then you're in arraignments, and whoever's there, maybe they're gray zone, maybe they're red zone, but the case might be blue zone. You don't know who you're getting and then you have to call the supervisor and be like, hey, who'd you assign this case to? And usually 5 days in, they still haven't assigned it to somebody.
Yeah,
best part.
In Manhattan, the only cases that you knew who the ADA was at arraignments were DV cases.
Now in Manhattan, you always know because the person who writes it up, their name is right there on your arraignment sheet. And they're also on the front of your complaint because they have to log it in.
I think that makes sense for DV because there's so much urgent matters to handle at that point. Yeah. Like we just spoke about Crawford for 3 hours. Right. So that's such an urgent matter that it's like I need to know who it is because I need to have this conversation ahead of time sometimes. So maybe we can resolve it before we get to court.
So tell me, explain. So obviously it's broken up and you might rotate, but I feel like basically the case for prosecutors, unless it's a warrant case, unless there's an investigation prior, it starts in ECAB. So how that work? Like explain a case. It enters ECAB. How does it enter? What's your day like? How long it takes? Who you calling?
So this thing is near and dear to my heart. The drafting of cases at the time that they first come into to your complaint room or the case assessment bureau or your intake unit is super important.
Okay.
And I don't think enough prosecutors do it right. Okay. One of the main things is you need to be able to make out a prima facie case in your complaint. What's whether it's a felony complaint or misdemeanor complaint. I know felony complaints have to be indicted anyway, but you have to be able to notify whoever is getting charged what the heck they're facing and why. Right? Sometimes people get arrested; they have no idea what they've been accused of. They just get told, we're picking you up, we're taking you in. Now we have an I-card, and we don't have to tell you what the arrest charge is.
And they'd be like, they didn't read me Miranda. They don't have to.
They do not have to.
They do not have to read you Miranda.
Miranda's just the right to remain silent.
It's
but if they don't want to ask you anything, no one cares.
Custodial, what is that word, interrogation?
Custodial interrogation.
Yeah. Custodial.
They can take you into custody, but that doesn't mean that they're going to interrogate you.
Exactly.
And asking you your name, address, and date of birth doesn't count. That's just pedigree.
Yes.
And taking them to like this is like there are tactics to get around this custodial interrogation that police officers use. Like instead of taking you to the interrogation room, I'm gonna just take you to my office, and there's a window here, and there's my other office mate here, and we're just having a friendly banter about, hey, how can I help you out, right? And that's that's a custodial interrogation, but is it? It is.
It is. But
you're not free to go. Yeah. That's custody.
Exactly. Do we know about it?
What do you mean?
Do we know about these conversations that happen?
Well, we know when they take you to an interrogation room, there's a
it's
camera
recorded,
they turn
right?
on, they record
but when they don't, in that scenario,
exactly.
do we know about it?
Not all the time, unless your client tells you, and then we can dig for a little bit. But then
if they don't use the statement,
I mean, we only know about it if they use it. If it's on, and then it becomes
it's like
I got a statement once. Yeah, I shot him. And I'm like, that could not have happened. That could not have happened. And it's a statement notice of a spontaneous statement. Yeah. And I'm like, you're really trying to tell me my banger of a client decided to tell you, yeah, I shot him because I'm blood. Right now. I'm blood. He quit, so I shot him. Like
I used to get, it's just weed, man. Back in when cannabis was illegal.
Oh, I guess so.
That one does happen. That one happens.
That is one of the
that one for real happens.
Time. I got arrested in 2018 for ended up getting DP'd. I ended up suing the city twice. This was to be the second time I sued the city for policing misconduct. And they They stopped me when I was walking. I just came out of work from legal aid. I was meeting with a friend in Brooklyn. They stopped us, said we were smoking weed, searched us, searched the area. There was nothing because we weren't smoking weed. Then took me, charged me with destruction of evidence, the E felony, because they said we're not giving you a ticket because we couldn't find anything. You wouldn't admit to smoking weed, so we're gonna charge you with that. I wait in the precinct for like 7 hours. They DP it. I then go. I then go to
that's
sue.
A crazy case.
And I didn't tell them I was. I didn't tell them I was an attorney at all. Like I didn't have no trust in them. And so like they found out. They found my secure pass and everything like that. And afterwards, when I'm suing them with my lawyers, we get the police report. And word for word, my statement to them is, what are you smoking? It's just weed, man. The same exact statement that every single marijuana case that I got when they were illegal. It's the same. Like, there's no way that everybody. First of all, I can guarantee you I did not say that. I have enough, like, even if it was true, which it wasn't, I have enough fucking discipline and experience to never make those. I invoked my Fifth Amendment right. I said, you're arresting me? Okay, I'm not answering questions to my attorney is present. There's no way I said that. My friend was there. He can confirm that I didn't say that. But yet, word for word, the same text that I saw when represented my clients was on my sheet.
So let me ask you a question, though. Because
yes, I smoke weed. No.
I feel like prior to body-worn cameras, I used to have the same perception as a prosecutor. Like, ain't no way all these people saying the same shit. Yeah. There's no way. When body cameras came, I was like, these people. I had a couple beers. That's the other one.
Yeah.
I love that.
That is the other one. I'd be like,
here's the
all
thing,
these people drinking beers. What about the Hennessy? What about the Patron?
And that they can talk their way out of it.
Here's the thing I want to be clear about. So
these statements are very common.
Yeah. I am a fully private criminal defense attorney now. I went from being a prosecutor to being fully private, and I used to really ask my officers questions. I used to really, like, I never ever let a officer just tell me. I needed to know how it was made, what the circumstances were the handcuffs on. We used to write every single thing down. My statement sheets were detailed. Pre-arrest, pre-Miranda, pre-handcuffs, question asked, answer, 1, 2, 3, everything numbered. There's no confusion. We're locked in for the long haul on this, and that was served at arraignment. And it was great for my colleagues, whoever had to take a case that I wrote up, because they got clear statements. They knew what they were fighting for and the circumstances. And honestly,
this is part of ECAB, right?
Yeah, and the reality is it's an important job because you're preserving evidence, but you're also not wasting time presenting a statement that's completely not admissible. You're making a decision. Now, what I will say to you is, as a private attorney, I get phone calls from people all the time. And you know what everybody does? What everybody does? These people they have jobs, they work. They all think that the police are there to help them.
Yes, 100%.
So what they do
100%.
is they go,
try to have a human conversation.
Look, it's just weed.
Yeah.
I had 2 beers.
Yeah.
And they think it's okay. I had a guy, military veteran, decorated, driving 80 down the West Side Highway, drinking. He blew a .19.
Sounds like an Army guy.
Okay? And honestly, look, that case was a tough case. Yeah. And I pushed hard and hard to get that case to the right place to keep this guy from having a permanent record. But the reality is, he confessed to everything. Yeah. And he's a military veteran. He knows that he's going to be in trouble. He still made a statement. It was all recorded. He goes to the IDTU room, answers everything, does the blow.
Yeah. It goes exactly. It's connected to what you were saying about having to tell complaining witnesses that you're not representing them because 90% of the people do not have a actual understanding, which is surprising because we incarcerate more people than anywhere else in the world, and you would think that the close connection to, like, everybody knows somebody that has contacts with the criminal justice system, statistically, just,
I won't lie, that's literally why I started this show. Because my clients ain't getting smarter. I've been here. I'm not the type of person that just allows a problem to stay unsolved.
Especially the recidivist.
For my own benefit. Pure selfishness. Like I want my clients to get smarter so my job gets easier. Because you can I can't hear I drank 2 beers that many times. It's like, yo man, shut the fuck up.
People never understand that, by the way, 2 beers.
1 beer
is totally enough to get over 0.08.
1 beer is enough to get arrested with the DWI. It's
1 beer is enough
if they say
to
they
get
pulled
you
you
brought in.
over for
A confession is a
speeding and
confession
you
is a
had
confession.
1 beer, then you could be arrested
It
for
was
a
only
DWI.
1 beer.
Yeah.
Yeah.
All right.
I mean,
It was
even-
only 1 mixed drink.
Fair. People are stupid, and they usually are their worst, our own worst enemy. Yes, I agree, 100%. I'm always telling my
I feel like we
clients.
just restored his faith in the criminal justice system. Now he doesn't think all cops are evil.
No, I do.
On that segue,
I'm sure there's some good, but most of them are criminals.
On that segue, I'm going to segue to a segment. This is called Adventures of Jeanne and Ev. This is a Jeanne. I know. All right, on this very special Adventures of Jeanne and Ev, I'll have a little hypothetical for you guys, and then you guys can tell me. Well, it's funny because we were talking about this earlier. Where exactly this police discretion came from, and how exactly does it work, and all just factors of just protecting yourself when you are hypothetically put in these circumstances. But what it is Jeanne was driving home from a night out with his wife on the Day of the Dead, right? And he had face makeup on half his face, like skulls and shit, right? And his wife also, hypothetically, had also on this on his face. They're driving. They're 1 block away from their home. They have to make a left and another left, so they're right around the block. And as they pull up to the light, cops just approach the car.
Describe the car.
It's a Tesla, hypothetically.
It's got rims and tinted windows.
No tinted windows.
No tinted windows.
Jeanne, hypothetically, does not believe in tints. It sounds like a excuse to get pulled over.
Oh, that's
She's ecstatic for that.
Tints are definitely an excuse to get pulled over.
Definitely an excuse to get pulled
It's
over.
saying, pull me over.
Pull me over. I'm good. No, don't pull me over. I have a Tesla. Ugh, scary. All right. So they walk up to the car. Eugene does not get pulled over in this hypothetical. He gets approached by police while at a red light.
On foot.
On foot.
Okay.
Foot patrol. They just walk up.
What county is this?
This is in Queens.
How many cops?
2 cops.
Okay.
Look at the lawyer question.
So like,
I mean, we got to do a
Jeanne believes that
hypothetical.
this must be a checkpoint. That's what it feels like. I don't know why you guys are just creeping up on me. Regardless of the skills Jeanne don't have, he don't know how a checkpoint's supposed to work and not supposed to work. I would imagine it's supposed to be like, hey, you're next. Like a little like fucking, come on down to the checkpoint. And you theoretically could bust a Huey if you had to. Yeah, but this is not one of those things. They just post up to the car and they go, hey, what you guys doing? We just came from a day dev thing, you know. We just came from the place. You been drinking? No, officer. You look like you've been drinking. No, have not, officer. Are you sure? You look drunk. You sound drunk. I don't sound drunk, officer. Jeanne says, I don't sound drunk. Officer goes, what's that? He goes, I don't know, officer. It's a beer can. Wife is trained. It's my beer can, officer. Not his beer can. It's my beer can. I've been drinking. I'm drunk. Officer, I'm not drunk. Jeanne is not drunk, I mean. Officer, like, I'm not drunk. It's like, you're drunk. I'm not drunk. I have not been drinking. I live right around the block. So what we doing? Because I have not been drinking.
He's got a quota to make, man.
No. This is what happens, allegedly, in this hypothetical. The officer goes, I know you're drunk, but I'm not going to arrest you. But I know you're drunk. And because I know you're drunk and I can't let you drive home, get out the car. I'm going to park your car and you can go home.
This cop is doing way too much.
Jeanne gets out the car. He's shocked. They can't figure out the Tesla because it's complicated. He gets back in the car. They bust a UE, they park. They get to walk on their merry way. I guess the question based on this conversation is, like you said, right? That is kind of more discretion. I guess maybe, there's a lot of factors, right? It's because it's a legal car stop.
This isn't a prosecutor question because we would never see it.
You're right. I guess the question becomes,
I mean...
I guess this is an ECAB situation, right?
No, they didn't make an arrest.
Oh, no. Because the funny thing is, the funny thing is, sometimes this exact case, which is, they have a weak case. It's a legal car stop, right? This is my understanding of the scenario, right? And this is why I know, even though Jeanne is being accused of being drunk, and he's not drunk, but he's being accused of being drunk, he wasn't arrested. One, it's a legal car stop, right? Two.
Well, is it even a stop because they're stopped at a red light? It's like more of a De Boer issue than anything, right?
Of course, it's more complex than it has to be for a cop, right? Two, he never admits to drinking, right? So it becomes, what do you really have at this point, right?
You have an open container.
You have the
vehicle.
smell of alcohol. You have the signs of, they're the same shit that they always
Yeah,
say.
you have the signs of intoxication.
Yeah.
Slurred
Watery,
speech,
eyes.
bloodshot, watery eyes, smell
Well,
of alcohol,
allegedly, right?
Well, they're gonna say it anyway.
Allegedly.
disheveled clothing,
Allegedly.
and you have an open container in the
That's
vehicle.
probably the biggest one that I would be concerned about if I was Jeanne. Well, at the end of the day, this person wasn't arrested, but this could have turned into a DP, right? Like the reason why this question is relevant to the conversation we're about to dive back into is that this is part of ECAB, right?
It wouldn't have turned into a DP because you have an 1192-1, which you have enough where the officer can articulate that you were showed the signs of intoxication.
Well, you don't think so? As a prosecutor, you're not concerned about why this cop even pulled up to the car to the window?
Yeah, but you're talking about an extreme of a DP at intake. Why not process the case and then investigate later about the stop and decide?
So I give you an example. I've been in scenarios where people have gotten DPs because they were not able. A factor of DPing it was that they were not able to get the refusal.
Yes, but in your
Because it's more than 2 hours past. So now all they have is observation.
But
they don't have observation of him
different.
driving erratically. So 1192
That's
subject
a little
1 would
different.
require the drinking to be impairing his driving. But they stopped him at a red light. They didn't witness any impairment in driving. They don't even have 1192-1. They have a ticket for open container.
Well, first of all,
Well, you don't.
We never got to
car
there.
stop doesn't have to necessarily be like so. Remember, 1192-1, you have to just prove operation. If you're talking about the procedural part of the stop, which will lead into the fruit of the poisonous tree to throw everything out, that's different from the actual charge itself. 1192-1, once you have operation and signs of intoxication, you're good.
Well, I thought it
You
was
don't
the
need a
statute.
good stop.
You need there's signs enough to walk up to someone from outside the car. If you didn't see them. If you didn't see
Is
them.
that not the officers?
It's not intoxication. It's intoxication to affect the ability to drive. So like you can legally consume a beer of alcohol below under 0.08 and if you're not speeding, if you're not doing if there's no science to say that alcohol you've consumed has impaired your ability to drive, then you can't be 1192-1.
That's a bad stop. That's not.
I think
meeting
we
the
should just go
elements
through
of the
it.
charge.
Let's just go through it one step at a time. Okay? So let's just start at the first thing that happens. The vehicle was operating on the road, right? We all agree on that.
It's operation.
The vehicle does not have tinted windows, so you can look into it. There's plain view. Yes. There are two people who appear to have been in some sort of celebration due to the face coverings.
Facts.
There is an open container in the cup holder. Yes.
That part,
Yes,
whether they knew
they're
that before they
also
walked up,
likely
is a
patrolling
question.
because of the type of night it is.
Day of the Dead, circumstances. Now, they did not stop the vehicle, so they don't have to say there's an articulable infraction, VTO infraction.
It was plain sight.
But the first thing they say is at level 2 De Boer, right? We agree on that?
What was the first thing you said again?
I knew you were
Where are you
drinking.
heading?
No. They walked up. They was like, "Where you guys coming from? What you doing? Where you
That's
going?"
level 2, right?
100%.
Okay, so we all agree that's level 2?
100%.
Yeah. It's
So
what's level
now
two?
we have to
It's
ask
inquiry.
ourselves. So
That
level.
is ignorant.
In New York State, we actually have 4 levels of street interactions. Level 1
And this
is
is
your
another
common
episode.
law, simple like, oh
Hey,
hi,
how you
how are
doing?
you?
Yeah.
What's you can an officer can ask anybody their name. You don't have to answer. An officer has to have a more articulable suspicion in order to get to level 2, which is to actually ask you questions. Where are you going? Where are you coming from? Things that they don't have the right to ask,
Which we call
unless they have a
inquiry.
specific thing. Level 3, which is a New York thing, right?
Detention.
Is your you can detain somebody, you can do a pat frisk for your
Terror stop.
safety. Terry stop, but it can't be a generalized thing like the Terry stops that are.
No, it has to be
for.
if the pat down has to be indicative of violence.
Well, you can pat down for your safety. If you get to level 3 and you're at the point of inquiry and suspicion, you can pat down for your safety to continue that process. But only for safety.
If the reason for level 3 is you think that there's a violent crime associated
Violence,
with it.
too far.
No, it is.
It doesn't need to be violent. It doesn't need to be violent.
Crime.
It just needs to be
A crime
if
afoot.
I'm at level 2
It's a crime
and I
afoot.
now have an articulable reason why I feel a little concerned for my safety. Maybe there's a bulge, maybe the way you're acting, maybe the way you're standing, maybe you're blading your stance. Any of these things, I can do a pat down for my safety. That is legally the way it's allowed. At level 3.
Oh, level 3.
And
Okay.
it's only
We're
a
at
pat
level
down.
2. We do these things. It brings us to level 3.
Oh, I get what you're
Right?
saying.
I can't start going and pointing and pocketing.
Now,
I can just pat.
No pockets, no zippers, none of that.
I'm looking. It's a pat down
And it has
for
to
weapons.
be for what you may be seeing that may be indicative of a weapon.
Yeah, and it could be any number of things,
weapons,
right? Like
yeah.
maybe
For
somebody's
weapons.
acting like maybe somebody looks like they're about to run away, right? Like they're backing up away from you a little bit. Maybe they look like they're about to run away, and you're like, we're in the middle of a conversation. I'm asking you a question because I'm at the articulable suspicion level, and now you're acting like you're about to run from me, and I'm scared. Or maybe you look like you're about to grab something. I don't know. I'm concerned. Little pat down to see if there's anything.
Yes.
So I can continue my inquiry.
That is a upgraded level 2. That is not, because I think we are literally, let's say you're at a 3 for a non-violent crime and there is no sketchy behavior, flight, or this jazz. You can't pat down.
True. Yeah. It's for safety only.
You
You
can't
have to be able to
You
articulate. There's a
can
safety
pat
concern.
down for safety.
Yeah.
No.
No, we agree with that.
No. Let's say, for example, the crime is a non-violent crime, petty larceny, right? And I stop you because you fit the description, but it's for petty larceny at level 3 for a non-violent crime, and you are not currently behaving in a way that is making you appear threatening.
Which this is subjective.
Of course it's subjective.
The police are always
At that point, it's not a pat down is not legal.
Police officers are always going to
But
pat.
obviously, if you have a bulge,
subjective
if you have
stance.
Because they also can pat for safety. They have a right to pat for safety. But regardless, back to this so we could get to your hypothetical.
For anyone who's not from New York, by the way, level 3 does not exist in all states, and it's not a federal rule. It is a New York state rule. Under people v. DeBoer. Okay, so we have four levels of street intrusion. The 4th level is your probable cause for an arrest and search. In the federal courts and in most states in the country, level 3 and level 4 are the same level. Okay.
Yep.
So the reason why I make that distinction is because the reason why we're parsing this and we're pulling it apart, we're actually struggling. We always struggle to pick out what's level 3 and what's level 4, whereas a lot of other places and a lot of law enforcement who come from outside of the state of New York don't understand
think
this
it's the
difference. They think it's the same. Okay, so we know that we were at level 2 because, or arguably level 2, because their question is clearly level 2.
Yeah.
Whether or not they're justified in approaching with level 2 is
Exactly.
I would say that's
I think we can say
it depends on what they saw. If they say we could see the open container from the street,
That's level
Yeah.
3.
Yeah.
I think it's.
Or
I think level
even-
2 gets some of the face paint, the day of the year, the fact that they're traveling at
Yes,
nighttime.
yeah,
all
all
of that
those
gets to level
factors.
2.
And
Yeah.
even
And then
maybe
you get
seeing her
close, and then they
drinking.
see the container. That's automatically level 3, and really level 4 because then they have enough probable cause for a crime to issue.
they have
an
enough
arrest.
for a
Damn, bro.
summons.
Who's the 88s? Nah.
I thought this was a hypothetical.
By the end of this, we're gonna have him turned around, okay?
All I want to do is I want everybody to take note that he made the statement. It was him. All defense attorneys, he made the statement.
Well, look, I think
You're gonna be silent on the stage.
I'm going to invoke my fifth.
I guess answering the question, right? Assuming this hypothetical is happening in reality, I guess, what do you think, what may, if a cop is out, because we talked about this earlier, if they have enough to go on, in theory, they just gotta go on it. What part, and I know that's not your job, but I guess it sounds kind of similar in the sense that what you think moves that discretion one way or the other, and what was their discretion in that situation?
I guess.
I don't know. Maybe you
I
don't know.
guess let's change your hypothetical and say that the Jeanne got arrested. Because I think that makes the hypothetical a little better.
No. I think that's easy. He got arrested because they thought he was drunk. That's not rocket science.
So what part of your hypothetical? So he parks your car. What's the question?
The question is an officer basically saying, I know you're drunk, but I am not going to arrest you.
He said, I know you're drunk and I don't want to do the paperwork tonight because I want to go home.
You think that's what it is? It's a pure paperwork?
No, let me
I don't
not.
think that's the
Cut,
case.
sorry.
Look, I think the moment Jeanne admits to drinking under this scenario, the moment he goes, okay, officer, you're right, I had one beer. He's going to the 112.
You're being investigated. Yeah.
He's gone. Yeah. I think the moment what I think is that what they were doing, it was a long three. And they didn't want to do a long three. They wanted a layup. And what they really wanted was I had a beer. Because the moment I had a beer happens, one, they're secure from like wrongful arrest, right? Because this guy articulated he had a beer. What if he gets to 112 and there's fucking a zero on it? Haha, motherfucker, I'm suing the fuck out of you.
Well,
I don't know. I disagree with you. I just think that I don't think an admission would have changed.
Oh, hell yeah.
no, it's
I think
100%
an
gonna
admission.
change it.
100 would
No,
have.
I think
110%.
110%.
no.
Oh, yes. Are you crazy?
So what I'm trying to say is, I don't think an admission makes the case stronger. Yes, but I think they had enough to arrest. Is my point.
Oh,
I disagree.
yeah.
And nine out of 10
I
times
disagree.
they're going to arrest.
Maybe the case wouldn't have went further than hearings, but they had enough to arrest. They have an open container.
I think you're misunderstanding my
Just because you
question.
said my girl is drinking don't mean
Okay,
that
of course,
that's an
of
open
course.
container.
You understand-
You have access to
No,
it. Could
of
have
course. You are misunderstanding my question, though. My question is not whether they did have enough arrests. They definitely had arrests. Jeanne, hypothetically, was like, I'm fucked. I'm about to get arrested.
Jeanne
Right?
got privilege
But guys,
in the
guys,
situation.
Maybe.
Period.
I think that's a big
End of
swing to
story.
say they had enough to arrest. I don't believe they did.
Mr. Tesla.
They needed more answers. But the big thing that would have helped them is if the wife didn't say that's her cup, right? Because then it's like, all right, either one of you could be drinking this. They need to investigate. Please step out of the car. Come to the back of the car. Watch your gait. See if the smell is the drink in the cup or your breath.
But that's my thing.
now
they
they're
had
doing
enough to do that too. They just chose
yes,
not to.
there we go. They had enough to continue the inquiry. They decided not to because, and here's what I think happened. Wife was well trained. Wife said, that's my cup. They realized, oh shit, she's saying she's the one drinking in the car. We could give her a summons. But we don't want to give her a summons.
They could have
and waste our time on
still
this.
kept going on him.
They could have tried, but I think that they came to the conclusion that, and look, not all cops are looking to reach the quota every single day of the week.
And I think that's the conclusion. I think they just chose not to pursue it in the moment.
Yes, they could have pursued
Not because they
to make
didn't
their
have enough.
investigation.
Not
No,
because they
they
didn't
had
have
enough
enough.
to continue the investigation. They did not have enough for an arrest. They had enough for a summons based upon the open container. They could not have arrested him based solely on the open container in the car and him having face makeup on.
No, but they said they had observations of
They said you
intoxication.
sound like you're drinking. That's.
Flirt
I mean,
speech.
the truth of the matter is, like,
He had makeup, so no bloodshot.
In truth, they wanted to get me to admit that they wanted Jeanne to admit that he's drunk. And how do you get someone to admit to they're drunk? You accuse them of being drunk.
Well, I mean,
I
Like,
agree.
those are the facts.
But they
It was a
could have
trap.
they could have still took
Yeah.
they could have still
They were
took
fishing.
Jeanne in the back of the car. They were fishing.
they could have asked him to go to the back of the car. They had enough to investigate. They did not have enough to make an arrest.
And had they investigated,
They probably would have found
arrested.
something.
Thank you.
They probably would have found something, and
They
Eugene
would've-
would
He
probably
was stone cold sober.
And Jeanne would have been
Jeanne
smart
is a
enough to say, "I'm
responsible,
not taking the
designated
breathalyzer,"
driver.
and that's it.
Jeanne is the most
Let me
responsible
ask
person.
Jeanne a question in this hypothetical. Was the body cameras on?
It's like a red light, right?
Yeah.
Yeah.
If the red light's on.
I don't know. I tell you right now, the Tesla's body camera was on because Tesla got 4 cameras and they on and that stopped.
Had the body
I'd love to see that recording.
They know that. You know what's the funny part
If you
here?
ever find Jeanne, I'd love to see that recording.
yeah, this is Jeanne.
Hypothetically. You know, with AI nowadays, you can make a recording of anything.
I will say body cameras take away a lot of discretion from officers in this day and age. It helps people in their cases, but it also hurts the discretion of officers.
Yeah.
Well, because there's a hierarchy that encourages things.
You know they can
and
get in
then
trouble
have to-
for that too.
They
for
can
not
get in
arresting.
trouble.
Oh, yeah.
They
Yeah.
can
I
get
thought
it.
they have discretion of when to issue.
No, with their
No, but
with
this
their
is-
body
this is-
camera,
they see-
they articulated it on the body camera.
They see something that could be worthy of
Dangerous for others,
investigation,
okay.
and it's a public safety concern. It's a big public safety
That body
concern.
camera was not on
Right?
that hypothetical.
And by doing what they
I can
did,
imagine
they
it
could
wasn't.
really could have gotten a command discipline. They could have been suspended. And look, how do you if you don't arrest the person who you've got who's worthy of an investigation? You don't even do the investigation. The next guy, how do you justify the difference?
Body cameras.
You could take anybody who hasn't crashed a car and tell them to park the car.
A lot of what happens at that side of the road isn't really. It's really when they take you to the station house and then they actually, like in the 5 boroughs, they don't do. They're not going to do the roadside tests and the breathalyzer doesn't mean anything on the side. They are going to officiate an arrest based off of whatever minimal evidence they have. What you said, right? And then they're going to take them to the station house, and then they're going to have them do the test, and if they deny it, that's another charge.
You do a lot of cases outside of New York City.
Yes, so you have to be trained to be able to do those tests, which is why a lot of officers don't and can't do it.
That's why they bring
They
them
have
to the
to-
station
so-
house to
yes,
do it.
because there's a trainer
But they officiated
there.
an arrest in order for them to do that.
The
They-
people
they
that
have
do
to
it
have
on
a basis
scene,
for taking you. They have to have a basis so they have to, that what happens
The
on the side of the
suspicion is
road
enough.
has to happen.
Well, what
It's
they're
not
gonna
enough
write
for
on
taking to the
what they're
precinct.
gonna-
They
what
have
they're
to
gonna write,
have
they're gonna say bloodshot
probable cause
eyes,
for an
they're
arrest
gonna-
before they take you to the precinct.
and the probable cause is the bloodshot, watery eyes, slurred speech, smell of alcohol,
Smell of
and everything.
The hypo didn't have bloodshot watery eyes. The hypo said,
not the
you
hypothetical
sound like.
sense.
Police are, but that's what they need. That's what a police officer needs. That's what he's gonna write, and then it's gonna be, and it's gonna get figured out on the back end.
let's not talk
In a
about
perfect
hypotheticals.
world, you're right.
Let's-
But in the
Yeah,
reality,
I'm not on the
Let's bring it
hypothetical.
back to ECAB, right? So you guys are brand new attorney. Just for
You don't even get
clarification,
the case.
do you do ECABs? Do you write up your own cases when you become felony attorneys?
No.
So in
Depends on the
a
borough.
vertical system, everybody writes up their own case, whether felony or misdemeanor, and they keep it. In a horizontal system, you might have a grand jury unit that writes up all the felony cases and then takes them and investigates them for indictment.
So basically, if you are in a vertical borough, you aren't ending ECAB just because you went from a misdemeanor attorney to a felony attorney.
Nope, you still get a rotation. You got to go in there. You might spend a week of nights. Might be there on the weekend.
Not in
Okay.
Queens.
Not in Queens. Okay, not now, but it was before.
No, not in Queens. Because if you're a misdemeanor assistant, you weren't doing felonies.
Oh.
So in Queens, there's an intake bureau. Everyone in the intake bureau, whether it was the old system or new, the intake bureau wrote up cases.
Yes.
Period. And now anyone in intake bureau writes up cases, then it gets assigned out after that.
Okay,
That's
so
it.
That's horizontal
Yes.
because
that's-
they're writing it up and it gets bounced out.
Yes, that's it.
okay, so now what?
No
let's-
matter if you're a felony assistant, you're never working intake unless you're picking up a shift.
Yeah.
And
So
that case doesn't come to you either.
No wonder why
sometimes.
nobody ever leaves Queens.
ECAB. What happens at ECAB? Because we've been talking around it. Like, explain what do they train you to do, and what do you actually do?
So the
And-
police officers make an arrest. They bring their charges to ECAB. You speak to the officer over the phone. You ask them what happened. You get all the facts, whatever it may be. Like we spoke earlier, if something isn't right, the case gets DP'd, meaning dismissed out of ECAB. Or intake is interchange.
Decline to prosecute, right? DP means
Decline,
Yeah,
yes, decline to prosecute. Most cases don't get declined to prosecute because a lot of times you need more information going forward. So the officer articulates everything that happened, whatever their observations was, whatever happened, why they made the arrest, et cetera, et cetera. Based on those facts, you determine the final charges. So like we mentioned earlier, officers sometimes upcharge, don't know the charge, or they charge based on the law, but practically speaking in New York, that's not how the law is prosecuted, so you choose the charges. For example, a lot of fights can qualify for a felony assault too. But in New York, you're looking for that significant injury to have an assault 2. So most cases are prosecuted as an assault 3. That's one example. But an officer will charge an assault 2 and then we'll prosecute it as assault 3.
Or hate crime it up to it.
Yeah, that's PTSD right there.
How many misdemeanor assaults and I had to defend as felonies because they were
That's in
able to back
Manhattan?
it up. Yeah.
Yeah, that makes sense.
No, my practice now is very different.
No, but when you were
When I was at
legal
legal
aid.
aid,
Yeah, I mean,
it
Manhattan, it
was-
has a lot of hate
Yeah,
crime
I'm
issues going on out
I'm
there.
definitely traumatized from fucking being there for so long.
I
All
can
right,
see
so-
that. So
so-
then you speak to the officer,
Yeah.
you find out what happened, you find out, make sure all the elements of that crime is there. You write up the case. A lot of the facts in the complaint aren't detailed facts. They're just facts enough to make out the elements of the charge. And that's it.
That's by design, I would imagine.
Yes. Yes and no. Yes, it's by design, but it's like kind of robotic. It's legalese. So it can mirror another complaint, and certain things are changed, like the name, the date, etc. But you're using legalese because it's the elements of the crime that's listed underneath the complaint.
My question is that is certain things left. So, for example, like the complaint, like you said, has to make out the elements. And it's legalese because you guys are using templates or whatever. It's like you're just making sure you make out the elements, so it's prima facie on the complaint, right?
Yes, because of the facts that you learned from the cop, and also from the complainant. Because if there's a complainant witness, you would want to talk to that person to find out from them what happened, because you're having it hearsay through the cops. You want to speak to them directly.
You need to.
Right, exactly. So it's only legalese because that's how the statute is written. So you have to use the statute's language.
Is there things you leave out on purpose? Are there things you train to leave out on purpose? Or are there things that are you trained to put in certain things on purpose? That's my question.
I think in terms of training, it goes to just the point of being a lawyer.
Okay.
You don't put detailed things in that, one, don't matter, or two, can change. Like you don't want to lock yourself into a red coat. If when you look at the video camera, the cop saw it red because of the light on it, and it's really a black coat. But sometimes that matters to like an ID, so you have to do that. You have to cross-reference that. But certain detailed things you necessarily don't want to include, because as a lawyer, why would you lock yourself into it if down the line you have to go forward and prosecute? Right, exactly. You have to look into it as well. So I think that it's training. It's just legal training. It's not like a forced training. Like, make sure you don't put this in.
Yeah.
But again, all you need to do is make out a prima facie case based on the elements of the crime. You don't need to detail that he made a left and then a right and then step back and then step forward. No, he punched her in the face and that was it.
Injury.
But more importantly, you can't write punched her in the face.
Closed fist.
Yeah. So you can't.
Why not? I don't even know. You said it like, why can't you say punch in the face?
Because that's a conclusory statement.
Conclusory
A
language
punch
is
is
make
conclusory.
officially insufficient.
He
You
hit
have
her
to,
with
you
a
have,
closed
you
fist.
have
Hit
to
her with a
say
closed fist.
he struck her. She had, for example, it's not this person struck. It has to be that somebody observed a strike to or the face. Now the hard part is you say to the face, on her, to near the face, about the face, right? Because you can't say it's punched in the face, because that, remember, words have meaning. In would be in. It's about punching on the outside of the face. You're closing a fist, or you're striking with an open hand. You can't say you either struck with a closed fist, right? Closed fist, because a fist is an actual description of what happens when your hand's closed, about the face. And then you have to reach out and say, all right, how many times? Is it more than once? If it's a couple, that's a couple.
Multiple.
If it's 3 times, that's several. If it's more than 4, that's numerous, right? You have to know that these words are binding to you, and it's a description, right? Why would you put how many times somebody struck somebody in the face? Why? Because you want to establish, for if you're trying to charge, for example, the assault 2, where it's attempt to cause serious injury causing only physical injury, right? You would be trying to establish how many times they struck them, how many ways they struck them.
There was multiple people, 3 people, 4
It
people.
goes to intent, it goes to injury.
If you have a gang assault, you have to be able to say that there's an observation of each person's part in the gang assault, because each person has to take part in order to show that they acted in concert to reach the gang assault charge, right? 3 or more people causing a physical injury by acting in concert. So this is the factual portion, and it's extremely important. And I swear, I am seeing more and more that this portion of these complaints is not written with as much care as it should get.
Yeah, they're not.
And I appreciate your carelessness as a public defender there.
I'm seeing it now as a defense attorney, how I used to write cases as a prosecutor versus the cases I'm getting, and I'm reading and I'm trying to find the facts where it's at in the complaint. I'm like, is this a fact or is this the law recited in it? Because I can't find it.
Which, by the way, You know where it's the worst? Manhattan.
Really?
Manhattan charges cases like this: assault, reckless assault,
They charge
attempted assault, aggravated harassment under subsection 4, which is just
every
harassment
assault.
as if
Right.
it's
All of
assault.
them come together, always.
And harassment. So every case is minimum 5 charges.
Yes, assault 3, attempted assault. Yeah.
He's
Really?
right. All
100%.
misdemeanors.
Now think about that.
Yeah.
I'm accusing
That
you of
doesn't happen other
intentionally
places?
assaulting somebody.
No, hell no.
Recklessly assaulting somebody, attempting to assault somebody, harassing that person, and if you harass them, I'm also saying you committed a physical injury, which, by the way, is just assault.
Yeah, but I guess.
Yeah.
They sometimes charge two harassment.
Which is exactly what happened in Jonathan Major's case. They charged everything under the sun, and they were like, well, okay, reckless assault, we're giving you that one.
Well, the crazy thing is,
It's cherry picking.
I did not find Jonathan Major's case that closely, but I don't know, based on what actually happened and what I would imagine was in the complaint, how he just didn't file a facial sufficiency argument.
Oh, he's appealing it. He moved to remove to set aside the verdict. But the reality is, he can't set aside a verdict.
No. I'm saying the defense attorney should have filed a facial sufficiency motion because it doesn't sound like there's actual injury.
They said they didn't know what happened in the
She
vehicle.
was injured. Her finger was bleeding.
And
She
he
was
broke her phone in the car. or
I'm
something
telling
like
you,
that.
I know a bunch of templates on assault that bleeding a finger is not actual physical injury.
It's physical
It's
injury.
clearly physical injury.
All right, that's physical injury.
That is impairment of a physical condition if I ever heard of it.
I won plenty of facial
This is the
sufficiency.
discount, baby, okay? Leo?
I've plenty of facial sufficiency
And
arguments.
the ADA's writing your cases wrote them wrong. Remember, I told you.
I
These
know
guys
who
are
you
writing
won
them
them in
more
front
and
of,
more.
probably.
That's what I'm saying. It really makes it easier to right and wrong. Because you right and wrong is like nowadays. So pre-2020, because I know we're talking a lot of inside talk. What a fucking baseball term is.
Inside baseball.
Inside baseball, but a lot before 2020, all you had was facial sufficiency to get rid of a case. Now you have discovery.
Yeah,
but what's
that's
more important, when I saw the discovery reform, the thing I was excited about is that there's no partial readiness.
Yeah.
There's no partial
No
readiness.
supplementary readiness.
That shit is crazy. Because you like all I want to see in a drunk driving case is a 511. They write up 511 so poorly. It's like all you have is a open container or whatever, anything that it becomes a poison pill for the entire case.
What's a 511?
Driving without a suspended license.
Yeah, but they
I
write.
mean, for the audience.
Oh, my
I know
bad.
what it is.
You know the funny thing is, I know
I know
there's
what it
gonna
is.
be magical words that just describe 511.
Oh, yeah, you should.
509 is what you want.
Oh, it's
for
part of it.
511.
Yeah, yeah.
Oh, you
So
do?
there's little footnotes, and they come out. They look really nice.
We call them citations.
Oh, okay, all right.
But like nowadays, if you write up, so like the whole point I'm bringing this up is because if you put all these charges on this case for no reason, you're just poisoning. Like if you put assault 3 when it's really harassment or really attempted assault, you poison pill the entire case because I can write a facial sufficiency motion towards the assault 3 and get the whole case dismissed. Which I feel like that's what they should have did in Jonathan Major's case. If they didn't do it, it sounds like they fucked up.
No, trust me. You don't practice in Manhattan, but you have to understand. These judges allow these complaints.
Yes.
Oh, there's no like.
You can't
like
appeal these.
that.
Now you
Yeah,
might look at them and go to yourself, everything about this complaint is designed to create a redundant verdict. Right?
That's
You
Which,
gotta-
by the way, is what
it's
happened
a
in the
culture.
Major's case. He intentionally
borough-
harassed
So,
her,
but if you
but
follow
recklessly assaulted her.
which is crazy.
Every borough has a culture. Like when I pick up cases in Manhattan, it's exactly how he describes it. It's multiple on an assault.
You can look these
simple
judges in the face and
assault.
go, Judge,
But
what
what happens when they see a
What
what happens when they see a facial sufficiency argument? They just don't take it seriously.
It depends.
it depends on the
it depends
facial
on the
sufficiency
judge
for
and
that,
the
it's
and
not
the
gonna
motion.
work.
Yeah, but
It's the standard.
what usually happens when you have those type of charges is at jury you can beat the top ones, you can beat the ones that you're like, and then the reckless is the one that you go down. There's like for some reason or another, whether it's a jury trying to just make everybody happy or you felt something was wrong and so they can
that's the
give a
problem,
conviction.
right?
You'll beat
What
every
doesn't make-
charge but one.
It has
Remember,
to
juries are not allowed to
it has to
consider the
legally
level of the
make
crime or the
sense.
possible consequences. So you hand the jury intentional assault and reckless assault. They're like, oh, well,
He
it
didn't
was an act. He
say, so
didn't
it
mean
wasn't-
to.
yeah.
It was reckless.
Yeah.
Fine. I
Yeah.
see the injury. I'm not saying it doesn't exist. I see the photo of the finger scratched up.
And they
What they're
said-
not saying is you're treating him with the same level of criminal culpability as if he intentionally assaulted her when he was defending himself from the brutal attack in the middle of the night.
Facts.
They said they didn't know what happened in the car. So
All right. So A big question before we move on to ECAB is, so you write this up, what happens next? Do you confer with a supervisor? Where does the bail amount come from? Is that your decision or is that your supervisor's decision?
That's a good question.
That's a good question. I don't. How is it done in Queens?
It changed.
Okay.
It used to be the decision of the arraignment supervisor,
Okay.
but it's intake supervisor's decision now.
Okay.
I mean, when I was an ADA,
I mean, I feel like they're trained more to understand the ramifications of the seriousness of a case, because in Queens specifically, they're newer ADAs. You're brand new in the office writing up cases. Yeah, you may know how to write up a case, but can you understand the in-between lines of what the value of this case is or how bad this could be, right?
Yeah.
So, like, you wouldn't want an ADA who's, like, new to this. You don't know what county they came from, what borough they came from. They could be from the hood or they could be from the suburbs. And you can't have that discretionary thing happening in arraignment. It doesn't look good. So it should be a meeting of the minds and everybody on the same page, even though it may not seem that way, but it's clearer when a supervisor has the authority to do something like that.
And how does the Bronx work?
when we were ADAs, when we were under Johnson, they had the horizontal system. What we did was we would write up our complaint, do our whole investigation. We'd go and we'd conference our final complaint, and then we decide on if there's going to be a plea offer made at the arraignment, or if there's going to be some sort of, and what the bail application is going to be. We'd write our bail application, what our argument is, but we decide the number together. By the time, after a while, you just sort of, make a recommendation and your supervisor just agree with you. After a while, my supervisors didn't even check. When I became a trial division, when I went to felony assistant and it was a vertical system, you had your direct supervisors in the complaint room with you. So your unit was collecting all the cases at the same time. So you'd pick up a case, you'd work on it, it's your case, you'd go and you'd be like, look, I think this case isn't worth the bail application, or I think this case is worth like a lot of bail. And generally, if your supervisor trusted you, it was going to be all good, right?
I like
But
that.
that was
sound better.
because you were responsible for it.
I like the bureau thing,
You
like
know?
everybody together writing up the cases, because intake is the trenches.
You know what's so funny is what I always hate, because I do my job, what I feel like as a public defender, what I do well is humanizing my clients, humanizing myself, and somehow making the ADA realize, hey, you represent me, my client, his cousin, you represent all of Queens. And I feel like that always helps me. And at arraignments, unless you have a high level ADA in there that can override whatever's happening in the back end, you can't sit there and go, what the fuck are we talking about, bro? Like, what do you mean? You actually for bail on this? This is crazy. Dude, why? This is why.
I would say that we worked as adversaries. We tracked to the same part. So we worked as adversaries, and every time Eugene came in the courtroom, I used to be like, oh my God, I can't wait to hear this story. And I would start pulling his cases out. Every case had a story behind it, like he was there. Every case.
Because every client is a person. Yeah. And I make you feel like he's a person.
And every defendant is a person. I always move like that. Every defendant is a person. Every complaining witness is a person, whatever. But you was there at the scene when it happened. Every time.
That's actually, how many of your colleagues were similarly situated to you guys, where you guys are from here, right? Was that common in the DA's office? Because for me, at Legal Aid, when I was in Manhattan, I was maybe 10% of us were from Manhattan, and maybe 20% of us were actually from New York City.
Queens, most people are from New York City. Very rare. You're not. They're Long Island mainly because I think the commute-wise, Queens heavy. The people that were from Long Island moved to Queens just to work at the DA's office, and very rare they're from like another. Maybe went to school somewhere else. Like I went to Penn State Law, but I mean I was from Brooklyn. I went to college in the city. But you've had people that went to other. States to other, went to law school in other states, but they came back to New York where they're from and they're at the DA's office.
I mean, I would tell you, I think if one thing I would enforce if I was a DA is a residential requirement years before. I know that sounds hard and impossible.
How are you going to get people to work?
You gotta understand though.
This is a government job. They don't pay nothing.
No. So you gotta realize, you might be 100% right and I'm wrong. But like the amount of like the difference between an ADA that is like us as compared to ADAs that's not like us is
They're not like
it's
us.
fucking it's night and day.
But you
It's
gotta
night and day.
you gotta understand. This is New York City.
Yes.
Okay. New York City is the center of the legal world for most of the entire earth. Do you know how much
100%.
lawyering goes on right here? Whether you're outside of New York City practicing, you are talking to somebody in an office in New York who decides.
Yeah.
So the same thing is true for the prosecutors. They come here. They come from everywhere. They come from Harvard. They come from Yale. They come from Duke. They come from Georgia. They come from UCLA. And yes, there's a lot of us. Like for example, I went to New York Law School. New York Law School has a lot of its graduates who go into the city and work in the government.
CUNY.
Corporation Counsel, same thing, right?
Yeah, CUNY, yeah.
And that's a great thing because you'll find that there's a lot of us who are bureau chiefs, who are in the mayor's office, who are in corrections, who are really like, we come here to work, to learn, and we stay here and we keep going, right? Mm-hmm. But there's also a lot of people who come here because the number one, most political, most likely to get you into the Southern District DA's office in the city of New York is in Manhattan.
Yeah, Manhattan DA's
Right.
office. That's
If you want to go, you can go to Richmond County if you decide you want to be a political figure one day, because they will. If you make it to a certain level there, you're in a good position to go and be a councilman. I know a couple of them, right? They started off in the Bronx, found their way to Richmond. Next thing you know, they're running for office, right? The same thing is true for Queens. Queens is one of the most diverse counties in the world. It's so diverse.
It's the world.
Right?
It's the world.
And when you think about how many different people, how many different cultures, you can't possibly represent them with just New Yorkers. You got to get people from somewhere else.
But here's your issue, like with the comment you made of why can't people like us be ADAs? Who the fuck want to work this job and not get paid? Most minorities that go and become lawyers, they want to make money. That was why. And
that was gonna be
like,
the original story of Jeanne and Ev, because I was gonna tell you my story about I applied to be a DA, and the only reason I applied to be a DA is because my 1L year, I got smizzled. I got smizzled. I'm not gonna bore the entire world with my GPA, but it was not nice. I was told specifically, don't put it on your resume. I got smoked, and I went to law school. I wanted to be a lawyer, right? I guarantee wanted to be a lawyer. I grew up as a child wanting to be a lawyer, but I didn't know what the fuck that was. I didn't know what it meant until I got to law school. And while I'm in law school, I'm realizing like, oh, okay, this is a business. I basically went to business school. Like everyone is telling me that this is a business, that it comes down to who you know, what law firm you get into, all this jazz. Mm-hmm. I got smoked. I went to my criminal law professor, which was the second half of the year, because I already knew I got smoked. I got smoked in the first half of 1L. I was like, hey, what am I gonna do now that my GPA is trash? Like, how am I gonna get a job? And what he said is, do something that GPA don't matter. Do something practical, where like your ability to do the job is paramount, which you'll learn through internships or externships, and your desire to do the job is all they give a fuck about. That's doing family law, that's doing fucking prosecution, defense, whatever.
Any service job.
And any service job, yeah.
That advice.
And then St. John's is a law school where if you end up going into service, between their mock trial team that they care about a lot, and their funnel that's literally in the building that goes straight to the Queen's DA, you'll be a DA. If you get into the prosecution clinic, which I did not get into.
Oh, well, then that's your problem.
No.
No, I'm joking.
Yeah,
I love being a public defender.
I used to.
I used to.
I think there's a couple of things. One, Manhattan is very just.
Manhattan is very unique.
It's a unique
I used to
place.
laugh.
It's a little toxic.
I don't think it's
I
like comparable.
I still meet defenders who knew me in the Bronx. They'd be like, and they used to, especially the Bronx defenders complains about the Bronx DA's office like they're the devil. And so you'll see Bronx defenders who now go to who would go to Harlem defenders, or they go to legal aid.
They're like,
and I see them and they're like, I had no idea how good I had it.
Oh, really?
I told you. You didn't listen.
And so like so there's one half of it's that, and I still like my heart is my first week of law school I was asked to speak on a panel about stop and frisk, and there was a professor there, Professor Bay Powell, and I saw how like she just there's also a cop on the thing, but she was just so good. I didn't know anything about law. Nobody in my family is a lawyer or anything like that. I knew I wanted to help people, like my community. I just didn't understand really how that was gonna, turn out. And I saw this person, and I was on a panel with her, and she was just so fucking good. It was that moment I was like, that's where I want to be. She's a warrior. That's what I want to do. And then I never looked back from public defense. Now, 7 years out of, or 1 year out of being from I don't know how to say this. After 7 years or 6.5 years of being a public defender, taking a break off, and then going back to criminal defense, part of me is like, I felt like cannon fodder. I feel like if and this may be a Manhattan thing, but like unless you come from money, you should only do public defense for 3 years and then get out and then make a life for yourself. Because especially in New York City, because you cannot make a living on it. Public defenders get paid less than DAs. You cannot make a living in New York City on a public defender salary.
DAs don't get paid. Yes, you guys do get paid less.
DAs just got a lot of raises. They're doing pretty good right now.
Well, speak for certain boroughs, but DAs, I will say, like, just for full transparency, starting DA in 2018 was $60K, and you just went through law school.
Yeah.
Teachers were making more than a DA. Without a law degree, like you get without a master's, just a bachelor. So it's like
out of 6.5 years.
And I mean charter school teachers. I can't speak for DOE.
Wasn't even cracking 80,000, right? That is like when you compare that to other lawyers in the profession. That's
especially if you're doing like 1,000 cases a year.
And I'm the type of person that I would go above and beyond for my clients. Always and will always come first. I will. Whatever. And to take that burden on, have the caseloads you have, and then not get paid as like a living salary. Like I'm from here. I shouldn't have to move out of here because I want to be a public defender, but can't afford to live in the city that birthed and raised me. And like there's a part of like and look, I may be a little disgruntled for a lot of different reasons, but at the end, I felt like it was cannon fodder. And it just was like, there's always somebody behind you, just take you out to the front lines and deplete. And I really think that, especially attorneys of color, when they're coming out of law school, public defense is a needed, just like, I would love if I can financially be in a place where I can work and not have to worry about it. I would 100% go back to public defense, like without a question. But like
you can't sustain a life.
You can't. It's a sad state for
society. I would say you can, but it's hard to practically sustain a legitimate, comfortable life. You can pay your bills, but
if I'm by myself, I was comfortable for a while, but if you have a partner, if you have kids, if there are just so many different
I think what it really is...
It puts you into poverty. Government work in general, as an attorney, I would say,
I'm making
in
so
a lot
much
of
more
ways,
money now than
put you
before,
into poverty.
And that is like...
My perspective is that like...
I wish I left 3 years ago. I wish I left after 3 years.
My perspective is that like I think
100%.
I think as a public defender you make enough money to take the job and do the job. What you don't make enough money to do is to see the opportunities out there and not reevaluate your life day to day. Because when you see the opportunity, especially as someone who started this, and I've also worked on commercials and worked with a lot of private attorneys, and when I realized like, oh shit, like I put 10 years into being a public defender so I get loan forgiveness. To get $400,000 off my whatever, right? Because it grew up to $400,000. But I've seen private attorneys. I'm like, oh shit!
I could have made
you would have paid.
Well, in those 10 years, I would have built a multi-million-dollar
100%, and your earning potential would have, after 5 years of doing doing private defense, would be. I mean, like, it just doesn't.
You got to think about it.
That's the math that doesn't add.
You got to think about it.
That math don't matter.
Eugene, how many trials you did, right? Calculate the trials you've done and calculate how much you could.
I've taken a lot of discounts.
The discon baby.
Come to me that. You'll do a lot of fucking trying.
God put me exactly where I needed to be to have enough time to make this show. I trust you guys.
So outside of your discons, think of your colleagues.
Yeah,
They don't
get enough discount.
The amount of trials they've done.
They seem stressed.
The amount of trials they've done, the amount of money they could have made for
of
trial.
course. 100%.
Your loans would have been paid off.
Yeah,
in 3 years.
Because like now I'm actually making like $60,000 more than I was making, a little bit give or take, right? And like I'm still just as attentive to my clients are still getting the same amount of attention.
I would imagine it's less. Your caseload got to be lower.
Oh, my caseload is lower, but like there's still all my clients have still my personal cell phone number. I did that my first. Like I would get told left and right by colleagues, don't give your cell phone number. Like no,
That's
I
crazy.
gave like
That's
my
crazy.
clients need to have complete access to me.
Hell
And I can set boundaries with people.
No. As a public defender, what I think is, if you have my number,
and I'm actually billing people. And like for having access to me, it is like my clients get the same amount of heart and energy and attention. Yeah.
Oh yeah.
He said, "Oh yeah, what are we talking about?"
what do you mean? You leave it
Like you said, it's a business. It's a business.
Cut that, Connor. Cut those angles. All right. Well, look. Go ahead.
You have to. Everybody here realizes that you're paid for your time and your experience. But when you come out of law school, and you go to the DA's office and you go to legal aid, the reality is you have neither.
Yeah.
You have no time and you have no experience and you don't have any skills yet.
Yeah.
So they take advantage of this.
Yes, 100%.
And they lock you in for
100%.
3 years. You're committed. So at the end of 3 years, all of a sudden they go, hey, we're giving you a raise. And you're like, whoa, $10,000 more than they made last year? Thank God! I was starving!
It looks like 5,000 still looks like a lot when you like
when you're not
in that
making shit.
100%.
So what
and
do you
you're
do?
sitting
You
there in
stay,
your
right?
calculator.
Yeah.
When I remember that when
You're
I
like
was
an
a
extra $100.
third year ADA, there was fifth years, really skilled, really talented fifth years. They were all on the rise, really well trained. They were all on the ROB. They'd done all their grand jury time. They were going into the felony division, but they were broke. They were broke. They couldn't do it. And the DA's office had hired a bunch of 1Ls who were making more money than the fifth years. And the fifth years were like, are you going to pay us to stay? And the DA's office looked them in the face and said no. So they all left. Every single fifth year left.
What year was this?
This was in 2017. Yeah.
Crazy.
They all left.
When I started.
I remember hearing about this meeting and I was like, holy shit.
They don't care.
They pay, and I remember, like, look, I remember then the next year, the boss went and got some more money. And the thing is, she got money slated for 1L. She didn't get money slated for 50. She couldn't give them the money. It's not that she didn't want to. She would have loved. She would have been happy to pay people more.
To get out of law schools to like more competitive, they basically raised them. Like they did that for us. Like I forgot when it was, but they what was the governor? What was the mayor before Eric Adams?
De Blasio.
De Blasio agreed to pay parity for the defense attorneys and kind of also the prosecutors with corporate counsel. Because corporate counsel, those motherfuckers,
They were making
bank.
Bank.
They were making bank. I had the chart for corporate counsel. They were making bank, and they agreed to pay parity. But this is pre-COVID, and they rolled out pay parity by getting the first like 4 or 5 steps actually at pay parity. I think it was pay parity with corporate counsel, which basically gave all these fucking straight out the box, straight out the fucking the womb,
brand new people
like $10,000, $15,000 raises.
I was training ADAs. I was teaching them how to do trials. I was teaching them how to review a case. I was teaching them how to write a complaint, and they were making more money than I did.
That's crazy.
And then you know, and I was a third. I remember I was a third year, and so in fourth year, they fixed their mistake. They gave everybody bonuses, not raises, bonuses. And then by my fifth year, I remember I was finishing my fifth year out, and then that was the first year ever that I was making at the DA's office more than $70,000. And I've been there almost 5 years.
Yeah, and if you talk to any other lawyer, and it gets me upset because if you talk to any other lawyer who does any other type of work, not real lawyer work like we do, but I have friends out of the second year they're making 200 plus, right? And it is such a disparity that it actually is a disservice to the society.
It's
right?
disrespectful also because
it's
the type of job we're
disrespectful as fuck.
doing is
hard and real.
It's hard as
important.
fuck.
people's
just
lives
think
are
it through,
actually
right?
on the
Like,
line, not money.
100%.
It's lives that are on the
100%.
line.
We're supposed to be dedicated, right? All of us, whether you're a defense attorney or a prosecutor or a judge, or you're a court attorney or you're a clerk, you're supposed to be solely dedicated to the job.
Yeah.
And you're supposed to think about the job
Ethical.
as a responsibility. You're supposed to be ethical. You're supposed to take it seriously. And you're not supposed to begrudge it. But if you work 40 hours and you're not allowed to work anywhere else because it's a conflict of interest, right? Or if you're like I was as a prosecutor and you're working
You also
60
need
to 70 hours.
approvals for outside businesses.
You can't start a business. You can't take
Really?
a second job. You can't even say. I remember I was in my
Thank
second
God
year.
for legal aid and their support of the First Amendment.
I remember in my
Thank
second year.
you.
You need approval. It has to go through the approval process because it's a form of like
Self-expression?
conflict.
Oh, it's called.
But, like,
Conflict.
I remember
You
in my
work
second
for the
year,
government.
I went to HR and I was like, hey, listen, is it okay if I take a part-time job on the weekends waiting tables for my uncle's restaurant, right? Just to make some money.
Even that you had to go for a
They were like, well, we're a little concerned. What if you accidentally give somebody underage alcohol?
Yeah.
You've
I
heard
knew
this-
it.
you've heard this
No,
line
I
too?
guessed it because why else?
They wouldn't approve me.
Why
They
else?
did not approve.
I would have became a bartender or something. Something cute. You
Like,
know,
yo, bro,
So, but
I'm
this
not
is-
even gonna
this-
work the
this is
hours.
how
My
it-
uncle's
this is
gonna
how
give it to me.
This is how it hurts society, right? Then you have like the experienced attorneys who have shown who have proven dedication to this specific field leaving, and then so my first class there were 14 attorneys in legal aid for the whole legal aid society, right? Half of them were from other divisions that were coming into criminal. This year, it's 100. It's 100 attorneys. The reason why, and I'll speak specifically for Manhattan, is because they're losing everybody. All of the experienced attorneys are leaving.
Well, don't forget that 10 years is up. All those people
I mean,
are done.
I couldn't even make it to 10 years because
Yeah.
it came to the point where like I was so beaten down, and this job is so fucking important to me that once I didn't have the heart to do it, I had to put my fucking 2 weeks in because I did not believe that me dragging my feet for people for this incredibly important role was I'd rather try to find another job while I'm unemployed than continue to do this and potentially hurt people because I'm not all in.
Because you're not all in. And
But you
that's
know what I will
fair.
tell you about being a prosecutor, right? And I don't know how you feel. I truly loved my job.
Love my job.
I loved my job.
Loved it.
Look, I took the subway for 2 hours each way to get to my job.
I didn't do that.
And
but I
I
loved
get this,
I would have loved my job slightly less.
and I'd wear sweatpants because I'd leave my suits in my office, and I'd get to the office, and I would always get harassed because I was late, and I'm like, I've been traveling since 6:30 in the morning. No one cared.
Crazy.
No one cared, and I didn't matter because I didn't care. I got there, changed into my suit, and all I did all day long was try to do the right thing. Now, I don't know if everybody does this. I think the majority of prosecutors try to do the right thing. I really do. But I also get into fights with people who I don't think are doing the right thing.
Because I think some people don't understand what the right thing is because they don't have the knowledge, the ability, the experience to decipher what the right thing is.
Because it's a revolving door of newer attorneys that get chewed up, and the older ones, if like
Or
I said,
people that just don't understand real shit. They don't understand petty larceny. People are hungry.
Look, all I can tell you is I remember
like
this.
you know, like things like that, like the little simple part of it. I've never met anyone in the prosecution office that didn't try to do the right thing. However, just what they thought the right thing was, I wouldn't agree with.
Well, here's the problem.
you know,
And this is the
They
real
see a
problem.
criminal and they're like, you must be guilty.
Some of these
Like-
people in the DA's offices just believe whatever the officer hands them.
yeah.
They don't dig deeper.
Yeah.
But I truly took Rob Johnson's words seriously. I always dug deeper. I always asked questions. I cross-examined my officers. I'd be like, look, I'm going to cross-examine you.
As
And that's what you're
upset
gonna
as
do
they
here.
will be, they'll be upset.
No, they all liked me. They don't have my personal cell phone. They used to text me, be like, "What's going on?"
I mean, I love that they liked you. I had to work through that, like, because as a first interaction, black female lawyer, and I'm not like, oh, I'm about to cross-examine you. Here's a flag. Yeah. I'm just about to start asking you questions to see if you can articulate, and then I'm gonna help you through your articulation. I'm asking you that not because I don't believe you. I want to know if you can articulate it, because when you go on the stand, this is what the defense attorney is gonna rub you on.
Oh, you're doing it before trial. I was just doing it first meeting.
Yes, that's before trial.
No. I mean, first meeting after I got the case, I was cross-examining them.
Yes.
Yeah.
That is before trial.
Okay, I'm just saying.
And most cases don't go to trial, so I'm not at the eve of trial. I'm like prepping my case because I'm trying to figure out what the hell happened at intake sometimes, and I'm on the phone. And after they get in the attitude, I'll be like, this is what you're going to be asked in the long run, so this is why I'm asking these questions. If you want me to prosecute this case, let me be able to articulate for you. Yeah. And that's where I was at with it. And they didn't like it at first because I wasn't waving a wand saying like, I'm about to do this. No, I want to see how you're going to react, right? Yeah. And then after, I'm going to get you back and I'll be like, listen, I get it, but if you want this, like, this is what it is. And this is where you're not going to make this mistake or think about next time you go to make the arrest. This is what you maybe need to think about because you may have Jeanne in the car, right?
Facts.
And you need to think about it. You're going to be like,
that'll be on your P's and Q's.
That 88 was asking you these questions at intake. And then I'm telling you, especially as a misdemeanor assistant, when I was actually taking my cases, when I met my officers, they loved the shit out of me at that point. I wasn't giving them my numbers. I wasn't.
I got along well with my officers.
Well, I give everybody my number.
They was getting my number when we was going to hearings because I needed to find you. However, they loved it after, and I've never had a bad experience with an officer. But in the beginning, when you are putting them on that stand early on, they're not happy about it. But it's a teaching lesson, and that's what I took pride in, being that person to be like, yo, everyone hates you and everyone's going to hate me, so we're going to figure it out and make sure this shit is clean.
You guys might be the most diligent prosecutors I've ever met because
we only got the best of the best for attorneys with swag.
Times I've cross-examined police officers on the stand and they are not, they have not practiced. They have
he wouldn't be sitting on his couch if he...
No, I'm just like...
Because we would have been like, what?
You guys are, and this is probably why you're not prosecutors anymore, but like you guys, like you guys should be the held up example for what prosecution should be. Because that's not the majority. And once again, this may be a Manhattan thing for me. I love you and I hate you, Manhattan. But like that has not been my experiences, and I've done a lot more trials than I should have, and it's the cops. That's the best part. Cops are they are not used to being questioned at all on the facts. They don't fucking watch the body camera footage. They don't do shit. It's like the only and in every single case except one, I put my client on the stand. I'm a firm believer in the importance of hearing from the client, and I can train you how to testify. That's my fucking job, is to go over with you again and again and again, so you're prepared for all of that, and it's effective. But yeah, I mean, it's just
I don't think. You I will say to you, because I know you got your Manhattan PTSD. I don't think. I don't think it's a Manhattan thing. I was friends with defense attorneys, i.e. one, while a prosecutor and after, and I've had this feedback happen before of like the frustration of just like dealing with prosecutors. But again, not everybody comes from the same walk of life to really understand certain things. So I mean, it's what we're faced with, but New York is very diverse.
Right, we're all people of color who are from New York City and grew up here, and that
government work.
Right. Well, not me. Yeah, we didn't go to government work.
That's government.
Sorry, buddy. You were a public defender. You got some city money, my friend.
I'm confused.
Are you not getting loan forgiveness? I'm
pretty sure
you got some city money, my friend.
I'm pretty sure government
loan forgiveness.
In the
It's not
words
the
of
government, 'cause
in the
I'm
words
the
of the
security.
prophet, 1, 2, 3, 4, 5, 5. I'm not gonna answer any more of these questions.
All right, well,
Just remember, court-appointed counsel.
look, on that note, we didn't get even halfway through our fucking script, but that's cool. We need a part 2. We're gonna leave it off at misdemeanor ADAs halfway through their job, and we'll catch back up, and the next episode will be about felony ADAs and the distinction and difference, and how having 5 years experience, if they pay you enough to stay there, can make the lifetime a difference.
Yeah.
Yeah, I stayed for 5 years.
Well,
I
imagine if they would have had you for 8.
Yeah.
But all right, well, before we go, anything you want to say to the audience before we go?
Me?
Well, I'll just give you an opportunity because I know you got a firm and shit.
Oh, yeah. You can hit me up, 917-572-8599. Criminal, family law, complex litigation. My firm does it all.
Mehdi Essmidi, EssmidiLaw.com. You can call me anytime. I give free consultations, and I know I look like I charge you for everything, but I am really very fair.
And the website will be right there. We do visual aids.
I gotta send you. You gotta edit out me misspelling.
Oh no, I got you. They will be right there. No mistakes. No mistakes on Attorneys with Swag.
And
Some mistakes.
Some mistakes.
But not a lot.
Mistakes are good. Imperfections are.
It's okay. The officer did the right thing by Jeanne in the hypos. That's all.
Exactly. Facts.
That's how you know it's a hypo. The officer did the right thing. I have bias.
Nia Fung, Joey Jackson Law. You can hit me up, 917-363-3353. 917-363-3353.
It's good.
And if you like what you saw, if you have any questions for episode 2, because we're going to do episode 2 on this topic, leave it in the comment section. Like, subscribe, share. Check out our merch shop, because we do sell merch. Help us out. We are soon to be a 501, forget that part, because 503c1b. No, that's not accurate. But basically, eventually helping us will be tax deductible very soon, or maybe right now, because who knows when you'll see this episode. But check us out later, guys. We out.
Coming like a prophecy, cause the work got us moving with velocity. We beastin' now, it's some monstrosity. We the plug to the source, unshockingly. Wow, what's he really gonna do now? Jolts in your system better stay on the ground. Volts in the circus as I spark to the sound. The energy that entered me are jewels in my crown. Wow, that's how it's always gonna be. You'll never really get it like NRG. Could do without the static and the flattery. Chill for I catch a charge like battery.
No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy. Just energy. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy, just energy. No weakness, just energy. Just energy, just energy. No weakness, just energy. Energy, just energy.